Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near, and they will be heard. God save the United States and this honorable court.
Please be seated. Good morning. Before we begin today, I want to take a moment to recognize that joining us today is Chief Judge Heil from the Northern District of Oklahoma, sitting by designation, and we're very pleased to have you with us, Chief. It is a great honor.
Thank you, Chief. Good morning.
And one housekeeping note, after the third case, 25-1113, we'll take about a 10-minute break. With that out of the way, please, counsel for appellant, make your appearance and proceed.
Good morning, Your Honors, and may it please the Court. Amelia DeGori as pro bono counsel for Petitioner. With the Court's permission, I'd like to reserve 3 minutes of my time for rebuttal. This is a case about basic fairness in immigration proceedings. The government did not turn square corners here. The government had in its possession, from its own detention facility, records showing that Diana is transgender, was being housed by the government in a transgender housing unit, and was receiving gender-affirming medical treatment. Yet it told the immigration judge just the opposite. Reopening is required for Diana to submit this undisputedly material evidence. Reversal and remand is also required to remedy clear error in the adverse credibility determination, which held Diana's timing in coming out against her and is otherwise unreasonable and unsupportable. Starting with the motion to reopen, the BIA legally erred.
Well, you started focusing on the transgender issue. The BIA found as a independent, sufficient ground to deny the withholding of removal that there was an adverse credibility finding on gang affiliation. Did it not?
The BIA said that that was dispositive for the withholding of removal. However, it's not reasonable to uphold an adverse credibility determination based on transgender identity, based on purported gang affiliation. Those are two separate issues at the BIA recognized.
Well, they are two separate issues, and that's the point. If the BIA found that one issue, gang affiliation, to be dispositive, why does it matter whatever failings and lack of squaring the corners that the government did relative to the transgender identity issue? Why is it even relevant?
Because, Your Honor, the potential gang affiliation credibility determination is as to credibility determination. It's not an independent sufficient basis just to deny withholding. It's going to why or why not the credibility determination can stand. And
The BIA said multiple times that this was a sufficient ground, I believe, to deny relief. And why is it, as a matter of law, not a sufficient ground to deny relief?
Your Honor, respectfully, the BIA said that it's a sufficient reason to uphold the credibility determination. The credibility determination is as to Diana's ability to present her case that she is transgender and fears harm on that basis.
If the only evidence that was presented at that hearing essentially relied on her testimony, and if her testimony was found to be incredible, then why would that not be a sufficient basis in and of itself as a matter of law? And if there's some authority that says to the contrary, now's the time to give it to me. But why, as a matter of law, would that not be a sufficient basis to deny relief?
Because a credibility determination has to be based on the totality of the circumstances. It cannot be it has to be based on specific cogent reasons for disbelieving the testimony and supported by substantial evidence and substantially reasonable. So it would not be substantially reasonable to deny relief on the basis that Diana is transgender based on her credibility as to a completely different issue. Just
Why
having.
not? If her testimony about being transgender and that being a cause of concern for withholding a removal is found to be, if she's found to be a liar, and that there's substantial evidence to support that, the BIA reference authority, which says that, you know, on issues essentially, well, one could say tangential issues, that in and of itself would say that why do I have to believe you on the transgender issue if I think you're a liar on the other issue?
Because the BIA itself recognized that these are two different issues, and if Your Honor looks at the BIA's decision in denying the motion to reopen, it recognized that these are two separate issues and that Diana's credibility as to her transgender identity is standing alone, so it's not affected by her credibility as to her potential gang affiliation. It would not be substantively reasonable to find, based on a single factor, that she was not credible as to her transgender identity if the court concludes that there is not a sufficient basis to uphold the adverse credibility determination as to her transgender identity. And there isn't here, because the BIA based that credibility determination solely on the fact that Diana and her mother had not identified her as transgender in 2017, 7 years before her proceedings in this case.
I'm looking at page 440 of the record, and the BIA says there, however, under the Real ID Act, an immigration judge may base an adverse credibility determination on any inaccuracies or falsehoods in the applicant's statements without regard to whether they go to the heart of the applicant's claim. And so the point which you've made, and I accept, is that transgender identity and gang affiliation are two separate things, but that does not, it seems to me, refute the notion that if the person offering the testimony regarding both issues has been deemed to be a liar on one issue, and I'm just referencing what the finding would be of lack of credibility, if the person is deemed to be a liar on one issue, why could the BIA not say, well, why couldn't the IJ and why couldn't the BIA uphold the fact that you don't trust that person on anything? Why isn't that law? I mean, that's a law in other contexts. It would seem to me that that could be the law in this context. The fact finder could say, I don't trust you, and therefore whatever you're going to say on transgender identity, I'm just not going to believe it.
But here, the BIA did make a holding as to credibility on transgender identity, and that holding cannot be sustained strictly by a credibility finding as to gang affiliation. There is clear error in that holding regardless, for the reasons that we've explained in our brief, that Diana does not have the tattoo that the immigration judge and the BIA claimed that she did have. And so that alone is not supported by substantial evidence. And the statute itself says that a credibility determination must be based on the totality of the circumstances, can't be affirmed based on a single factor when that factor is unsupportable, as we have shown that it is, because there is not substantial evidence to support a there is not substantial evidence to support adverse credibility as to a gang affiliation.
Why is that the case? I mean, the notion that Diana was a fan of Friday the 13th, and therefore that supports why she has the tattoo. Why couldn't the BIA, why couldn't the IJ and then the BIA after that find that just to be fanciful and therefore implausible and therefore incredible? Why is that? What makes sense? What is not reasonable about that line of reasoning?
Your Honor, the BIA did not uphold the IJ's determination on that basis. The BIA said that the IJ permissibly concluded that the applicant's M13 and locus tattoos were an indication of gang affiliation, and the applicant's testimony to the contrary was not credible.
Counsel, you make a lot in your brief about an M13 tattoo versus just a 13 tattoo. Who introduced the letter M? Who was the first person to mention the letter M?
Your Honor, Diana was the first person to mention the letter M, but she did not say that she has an M13 tattoo. She did not say that she has an M tattoo. The DHS attorney is the one who introduced that falsehood into the record. And so the credibility determination.
She said that 13 could stand for a number of different things, various things. And she said, for example, it's the 13th letter, it could reference M for Mexico. What is her connection to Mexico, if any?
Your Honor, that there's no indication in the record that there's a connection to Mexico.
But she's the one that said that, right?
She explained that different tattoos have different meanings to different people, and that, for instance, M is the 13th letter of the alphabet, so 13 could be standing in for Mexico as opposed to something different. That is not, again, the basis on which the BIA upheld the IJ's credibility determination. The BIA was relying on the idea that Diana has an M13 tattoo, which she does not have. So substantial evidence does not support that determination. And at minimum, Diana should be permitted to reopen the proceedings to present the evidence that she does not have an M13 tattoo, and this was a falsehood introduced by DHS.
So could I just ask you, I'm looking at the BIA decision, and it talks about the adverse credibility determination on gang affiliation, and said that that alone is dispositive on withholding of removal. And then the BIA turned to the Convention Against Tort Relief based on CAT, and says that the adverse credibility finding on transgender seemed to be the basis to uphold the CAT determination. Do you read the BIA as, I understand the colloquy between you and Chief Justice Holmes about an adverse credibility determination on one point applying to the rest, but didn't the BIA separate out withholding of removal in CAT and affirm on different credibility determinations?
Your Honor, admittedly, the BIA's decision is not very clear on this point, but I do agree that the basis for the finding on CAT was adverse credibility determination as to being a transgender woman and whether or not that she was able to establish that she would more likely than not suffer torture if returned to El Salvador. So I do think that the BIA can be read to have separated these two issues and not considered the gang affiliation issue dispositive as to her credibility on the CAT, because it did say it's dispositive of her application for withholding of removal. But in either event, it would not be reasonable to uphold the BIA's determination based on credibility as to the gang affiliation.
But looking at page 442, it appears that as it relates to the CAT determination, that the BIA also said that even if it could be assumed that she would be tortured by virtue of her transgender status, there was no basis to believe that that would have been with the consent of any public authority. And I didn't see any argument in your brief about the consent issue. And why isn't that in itself an independent basis to find that CAT relief would not be available?
Because, Your Honor, in the BIA's later decision, it clarifies that the only thing standing in Diana's way in terms of receiving relief under either form of relief is the adverse credibility determination as to whether she's transgender. It said otherwise.
These are two different orders. I mean, I don't. Let me know the basis for bleeding those two orders together in terms of the rationale. I mean, this order stands on its own. This order has been appealed on its own. And should not it stand or fall based upon the reasoning that's in the order?
Your Honor, these proceedings are consolidated by statute, and the agency has clarified in its later order what is the basis for holding against her in the earlier order. So this court can consider that the BIA, the agency itself, clarified its reasoning in the earlier order when it said that She has made out a prima facie case for relief. The only thing that was holding her back from that was the adverse credibility determination. And as a matter of the government's own evidence, medical records indicating that DHS itself was providing her medical treatment while in a DHS detention facility and housing her in a transgender housing unit, that she had made out a prima facie case for relief.
And how is
because-
the basis, what is the basis for that, when the evidence that, the whole point of the reopening proceeding is that you were presenting things that you didn't present in the other proceeding? And so how can we judge the merits of the CAT determination in the, well, in the initial proceeding by bleeding in stuff in terms of whether she made a prima facie case that existed in the reopening proceeding? I mean, that, how does that make sense?
Your Honor, that it's not whether she was able to present evidence in the reopening proceeding that should bleed into the adverse credibility
No,
determination.
I'm talking about the, specifically, I'm talking about the CAT determination and the BIA's statement that irrespective of whether she made out her case on being transgendered and that would cause that she would be tortured as a consequence, that there was no basis to believe that would be with the consent or acquiescence of the government. And is that not an independent ground to deny CAT relief?
Your Honor, that there's a conclusory statement in that later opinion that confuses the grounds on which she presented her basis for CAT relief. I see my time has expired, so I will just point Your Honor to the case cited in our brief that the BIA can clarify its later decision-making and show that its reasoning in the earlier order should be vacated.
I'll give you a little rebuttal time.
Thank you, Your Honor.
Could I just ask her one more question? I think this builds a little bit on what the Chief was asking you, but one of your arguments is that we should remand because the BIA didn't address a bias and unfairness argument, correct?
That's correct, Your Honor.
In addressing this, may this court consider the motion to reopen fairness arguments and record, given that the appeals are consolidated? I mean, I'll give you, for instance, I mean, you're arguing that she didn't have the medical records. DHS counsel cross-examined, tried to impeach her on transgender identity, but at the same time, the records, DHS had the records. I think that's
Correct.
the gist of your argument. Can we take that into account in addressing your request for remand for a bias fairness determination as to the initial April 2024 hearing?
I think Your Honor could instruct the BIA to consider Diana's bias and fairness claim in the first instance.
I'm looking more for some authority that would allow us to do that. Are you aware of any?
Well, Your Honor, the Mikovichute case requires a remand if the BIA hasn't considered something. And so if this court concludes that the
No,
BIA...
that isn't my question. My question is, can the record there's two appeals, they're consolidated. Can we consider the record in appeal number 2 in considering any of the issues in appeal number 1?
Your Honor, I think that the statute consolidates them. I'm not aware of authority giving the court permission to consider completely separate record evidence in the second appeal in order to decide the first appeal. However, the court can instruct the agency to consider Diana's bias claim in the first instance based on the record that's before the agency. Thank you, Your Honors.
May it please the court, Anna Juarez for the respondent, Attorney General. Petitioner had the burden to establish a credible and persuasive claim for protection from removal. She failed to meet that burden and now further fails to identify record evidence compelling that she established a credible claim for protection. Petitioner also bore a heavy burden to establish that reopening was warranted, but failed to meet that burden as well.
Well, why don't you take a crack at answering Judge Matheson's question? Are you aware of any authority that would allow us to consider the record in the motion for reopening in determining whether it would be appropriate to grant remand on fairness grounds in case number 1, given that there was some notion that the government had the evidence that would have supported the transgender claim and was sitting on it, and therefore, nevertheless impeached Diana at the time?
Yes, Your Honor. In the consolidated case, generally the court can look at the whole record. However, I think it needs to look at what was before the agency at each step. Before the agency in the first step, there was just no evidence that she was getting gender-affirming care. She didn't bring it up. It was her 3rd time in removal proceedings. She claimed she was detained in pro se and did not have access to records, but no one was requiring her to access her detention records. She brought up for the first time before this court that DHS had a duty to submit those records. However, there's just no indication in the record that the trial attorney, essentially a prosecutor, would have access to her personal medical records in detention without being notified of in some way. And so in the motion to reopen.
By whom?
By her. I mean, she had an opportunity. She was questioned thoroughly about her claim. She filed her own declaration about her claim. And so.
You use the word prosecutor, and so let me try to engraft a concept on here. Why would it not be the case that the prosecutor in this instance, on what would have been material to the claim of transgender identity, would not have had to inquire whether there was any record of gender-affirming care, because that would have been something that would have been relevant to the determination of whether she should get relief or not, right?
Correct, and I should, I'll retract the prosecutor analogy. She had the burden to prove her claim at every step of the way. It was her burden. Even being detained in pro se, it's her burden to establish it. The transcript shows that the IJ did question at length. DHS had no burden to...
Did the IJ ask anything about the treatment?
The IJ did not ask the specific question, have you received hormone therapy? And all of the arguments about duty to develop, I mean, they kind of come down in this case to that one specific question.
Could I just ask,
Yeah.
maybe backing up and looking at this big picture, do you agree now that Ms. Munoz-Ramirez is transgender?
The government doesn't dispute that.
Right. And there were records in the file on April 4, 2024, that she was getting treatment for being transgender.
There weren't, not necessarily in the record. DHS, the detention center, had those medical records. There's no indication they would be in a trial attorney's.
No, I understand, but
Yeah.
but at this point, we know they were there.
Yes, they existed.
And they're in the record now.
They're in the record now.
Have you considered conceding that she was transgender on April 4, 2024?
Even if she is, we are conceding she was receiving that gender-affirming care. As Your Honor pointed out earlier, she's still not credible. There were still reasons. The court can accept that she is transgender.
Well, we're just on the gender identity credibility determination. I mean, how is that not clearly erroneous given what is known now?
She still had the burden in both of the cases. She wasn't credible. She wasn't credible for independent reasons.
I'm not talking about the other reasons right now. We're just talking about gender identity.
Yeah, and for the motion to reopen,
Credibility determination, looking at it broadly, clearly erroneous.
just the transgender.
Yes.
As the board said in its second decision, it was material to that one specific issue.
I didn't ask whether it's material, I just asked, is it clearly erroneous? Looking back now, I mean, we've got records that she was getting treatment before the hearing.
The board at that,
Jay, she was transgender. She was getting treatment. Records now confirm it. Now, I understand about records from the one appeal and the records from the other appeal, but as a practical matter,
at,
how can that credibility determination be correct?
well, at that time, there were no records before the board when they made that decision regarding, so arguably, that was not clearly erroneous at that time.
Government, in the face of clear documented evidence that she was transgender on April 4, is not willing to say that that credibility determination was clearly erroneous. Is that your argument?
Not at that time, but the government also,
I know, we're talking about now.
yes, what the agency had before it at that time was not clearly erroneous.
I mean, why wouldn't it make sense to have it go back in light of everything that's happened?
And that would be a matter of the motion to reopen. I mean, any evidence could come out after an agency decision.
Arguing that the IJ hearing was biased and unfair, and the BIA didn't even address it. So aren't we required to send that back?
That also was specifically with the transgender claim. The BIA majority decision did not address it. They did in the dissent. The record shows that the IJ gave a full hearing to show bias. There needs.
But is that something we can decide? Can we go back and look at the IJ hearing and say, oh, it wasn't unfair or biased? Or is that something that the agency needs to decide? It's just as a matter of basic administrative law.
A couple of different responses to that. Generally, procedural due process the agency needs to look at first. The overall, though, constitutional questions are de novo. And I think in this case, it doesn't, because it goes to transgender, she's not claiming a duty to develop the record regarding all of these inconsistent claims. It's really just the transgender part of it. And she really is not disputing these other grounds of adverse credibility and, she was given the opportunity to explain them. The BIA said we would find her adversely credible based on this dispositive ground, plus a few other grounds they noted.
And help me with this.
Yeah.
I mean, if in fact, as I read the BIA decision, it was dispositive that she was not credible as it relates to gang affiliation, what difference does it make? I mean, if on the motion to reopen, if in fact the issue is she carrying out her burden of proof and she is found to be incredible, why is that not a sufficient basis for the BIA to deny relief, period? And what I want to disaggregate here is a question of fairness and what should happen from whether, as a matter of law, the BIA was obligated to do anything else. That's a question.
I agree, Your Honor. The board was very clear about that being a dispositive ground. It separated it from the transgender, which brings in all of the bias, duty to develop. The board absolutely can deny based on that ground. As Your Honor noted previously, the statute says that it doesn't need to go to the heart of the claim. She's never actually denied or rejected the IJ's findings regarding the inconsistent testimony about why she got the tattoos. The only argument she's making now is she didn't even raise it to the agency that one of the 3 tattoos she doesn't have, there's a logos, a 13 and an M. She, as you pointed out, introduced the M. DHS followed up and said, your M tattoo means Mexico. She said yes, and then has not brought it up until the briefing before this court. And whether or not the M exists, there's plenty in the record that the court could uphold the adverse credibility finding based on that alone.
Counsel, I have a question for you. So I understand it's the petitioner's burden, but I want to talk with you a little bit about the record that Judge Matheson inquired about. So there's a case that cited the matter of MAM, and it talks about DHS's obligation to provide the court with relevant materials in its possession regarding the respondent's mental capacity as a safeguard where the respondent's competency is at issue. We don't have that issue in this case, but we have an issue of whether she was transgender or not. What is the Attorney General's position on whether that case would support an obligation on behalf of DHS to provide whatever record it may have had, if it could have had some relevance at all?
The matter of MAM and the mental incompetency, that comes into play when there's some indication before the IJ that an individual has mental competency issues, and then DHS is tasked with helping find records. It really does not come into play here. No one has extended it to just other medical records. And again, if it was even analogous, there would have had to been some indication before the IJ, for the IJ to ask DHS to go learn about this.
Say we should expand that decision to cover any and all records that could have any relevance at all beyond the mental competency issue.
I'm not aware of that, no.
Isn't that what the regulation says? It's CFR section 1242A. It says DHS counsel shall present on behalf of the government evidence material to the issues of deportability or inadmissibility on any other issues that may require disposition. Why didn't that impose an obligation to disclose the medical records?
I think in this case, DHS trial counsel didn't know it was something to disclose. There's no indication that
To inquire or check the records?
it would be one thing to say that in hindsight, but there's nothing in this record that indicates that that would be something to discover. And again, this.
In the motion to reopen, though, it suggests that maybe it's a little more than hindsight. That is, there were records, and yet DHS counsel presented it before the IJ as if there weren't any.
Yes, Your Honor, and before the IJ, this was petitioner's third time in proceedings and the first time that she claimed to be transgender. And so it's not entirely unreasonable that DHS would not be, or would be skeptical.
Let me follow up on
Yeah.
the regulation. Does the regulation impose a Brady-like obligation on DHS to present information that might be exculpatory? I mean, there's one thing to say you should present things as the person trying to seek remove somebody, you should present things that are material to that removal. It's another thing to say you should search for records that might be material to proving that that person should not be removed. I mean, is there any sort of Brady-like obligation on DHS in these contexts?
There is not, and Brady is applied in criminal proceedings. This is different, and there's that.
Clear. What I'm talking about is the need to present exculpatory or information that might be favorable to the alien.
Yeah, there's nothing in the statute of regulation that requires DHS to do that. It just requires that she has the burden. DHS did not have the burden in this case. We would argue that she did not meet her burden. I see my time is up, but I'm happy to answer any further questions.
I mean, other than saying that she was transgendered at that time, did she say that she had received treatment?
No, not during her proceedings.
Thank you, counsel.
Thank you, Your Honors.
A minute and a half.
Thank you for the additional time, Your Honor. I'd like to pick up where the panel left off with my friend from the other side. The regulation imposes a duty on DHS to present material evidence, not any evidence that would be favorable to the applicant, but evidence that's material, as the BIA concluded that these medical records within the possession of the agency were material.
And I'll pick up on Judge Hiles' question. If she did not indicate that she was receiving treatment, why would the DHS counsel even know that they were material? That would create a very different scenario. If she had said, look, I've been getting treatment, and then the DHS counsel ignored that and acted like it didn't happen, we might be in a different situation, but that didn't happen, right?
Stepping back here, Your Honor, DHS had to pick a lane. It affirmatively disputed before the IJ her transgender identity and accused her of lying. The DHS attorney didn't just say she hasn't met her burden and left it at that. It went beyond and said she's lying. And so when...
Different answer to that's not the question. The question was, did the petitioner ever say that she had, beyond just being transgender, did she ever say, I'm actually receiving treatment? I have received treatment in your facility. Did she ever say that?
No, because the IJ only asked her 2 questions regarding her transgender identity. When did you start identifying as transgender? And when you say you're transgender, what does that mean to you? I see my time has expired. I request that the court grant the petitions and reverse and remand.
Thank you. Thank you, counsel, for your fine arguments. Case is submitted. Next case this morning is 25-1082. Provide investing dollars of Armistice Capital Master Fund. Counsel for Appellant, would you make your appearance and proceed, please? Counsel for Appellant, if you'd make your appearance and proceed, please.
Thank you, Your Honors. Dan Doherty for the Appellant shareholders. I'd ask for 1 minute for rebuttal to be reserved. Following the stock market crash in 1929, Congress investigated causes of the crash, and one of the causes was that there was rampant insider trading by officers, directors, and shareholders of public companies. The 1934 Act was passed in response, and its purpose was announced to provide for the regulation of transactions in the public markets, including those by officers, directors, and principal shareholders of public companies, so as to ensure fair and honest markets. Part of the 34 Act is Section 16B, which requires officers, directors, and principal shareholders who engage in a sale-purchase couplet within a period of less than 6 months to disgorge any profits made back to the issuer. 16B allows the SEC to make exemptions for transactions, quote, not comprehended within the purpose of 16B. It wasn't long after the passage of the 34 Act that it became apparent that 16B posed a huge impediment to stock compensation for officers and directors. The SEC responded by enacting Rule 16B-3, first in 1935, which I understand was a temporary rule, but later in the 40s and all the way up to today, it is the principal mechanism by which officers and directors are able to acquire stock from the company without having to worry about disgorging any profits. The problem was this: stock compensation normally takes place on a 12-month cycle. Section 16 looks back 6 months and forward 6 months. And so it acted as a permanent bar to ever reaping the fruits of stock compensation, which is meant to incentivize management of these corporations. Okay, so it acted almost as a permanent bar. That's the problem 16B3 was designed to address.
And as I understand it, your position is that the SEC exceeded its authority in enacting 16B3, right?
They exceeded their authority in 1996 when they removed requirements that would, in particular, the requirement that the shares come out of a shareholder-approved plan. And so it opened the exemption up to directors who are not part of management. In other words, directors by deputization. That's what this case is all about.
And to that question, do you think that the SEC would have exceeded its authority if as it relates to directors who are humans, as opposed to, you're talking about directors by deputization? Directors by deputization, Your Honor. If they were human, the SEC would have been within the bounds of its authority. I believe they would have been. I mean, it's a question, but we're not questioning that aspect of the rule. I mean, we're talking about what are the bounds of what the SEC can do. Well, if most of your arguments would be equally applicable to the SEC's authority as it relates to humans and directors by deputization, then why isn't that a concern? I mean, because one would have to know how far your argument goes,
Okay.
right?
I think the SEC can make rational distinctions between directors who are managerial directors, I'll call them, human directors, versus shareholder directors. For one thing, scale is important. We have in our reply brief a report by F.W. Cook that says that for companies the size of A2, the number of shares granted on an annual basis to the whole group of management is less than 2% of the outstanding shares. When you're talking about an institutional investor who's a director by deputization, the scale goes way up. In this case, we're talking about an acquisition of 10 million shares at a time when the company only had 21 million shares outstanding.
Well, Counsel, you just said that you believe the SEC can make a rational distinction between directors who are human versus directors who are directors by deputization. Can they not then make a rational decision that they don't want to treat those differently?
Well, they could, but
Isn't that what they did?
Oh, well, I don't think they did. I think it was inadvertent, frankly, because there's nothing in the releases that ever speaks in terms of officers and directors as anything other than managerial, members of management. If you look at the language of the releases, it says based on the premise that most, if not all, transactions between the issuer and its officers and directors are for compensatory purposes. That was the premise, even in the 96 release.
So here we have master fund, right? That's the director by deputization.
Correct.
Could an individual be a director by deputization?
For example, not that I know of. I suppose they could. They'd have to be very wealthy individuals.
Is that the understanding under the rule that the director by deputization is some sort of institutional investor?
Well, the rule evinces...
Universal understanding?
Pardon?
Understanding?
Well, the rules, the releases by the SEC show no consciousness that shareholders are in view at all. The only time they mention shareholders is to say they're not eligible.
Well, it was the courts that introduced the notion of director by deputization, not the SEC, correct? It was used in an offensive manner, not a defensive manner first, right?
Correct. Blau v. Lehman was the first case to recognize that the concept of director by deputization, but found none in that case.
And when given an opportunity to opine on it, the SEC in an amicus brief in the drilling case, wherever that's pronounced, said, yes, that is within the scope of 16b3, right?
They did, and the justifications they used were really two. That the board of directors is an adequate gatekeeper between the insiders and the company, and two, that there's informational parity between these insiders and the company. Problem with the gatekeeper argument is the board of directors is guarding the wrong gate. The gate that the 16B is concerned with is the gate between the insiders and the public markets. State law already provides provisions for protecting the issuer from, fraud by its own directors. In terms of informational parity, the result of this is that if a shareholder by a director by deputization, who's a shareholder who has a deputy on the board, feeding it information to influence its investment policy in the issuer, has access to the exemption, but a shareholder with just as many shares who has no deputy and no access to inside information cannot access the exemption. It's backwards. And it's backwards because I don't believe back to the dryling cases, the SEC's justification. Look, if informational parity is a ticket into the exemption, why isn't informational inferiority? This shareholder without a deputy cannot access the exemption. That's just not reasonable. It's not a reasonable outcome.
Counsel, could I just, this is sort of backing up a bit.
Okay?
But the issue you're presenting for appeal is whether the SEC lacked statutory authority to exempt board-approved transactions between issuers and directors by deputization. That's the issue presented. But in district court, it seems that the thrust of the arguments were more a matter of interpreting the rule, not so much whether the SEC had authority. And so I just have to ask whether this issue has been preserved.
Your Honor, we actually mentioned both bases for.
Did you mention it in your initial motion for your cross motion for summary judgment?
We asked the court. We argued that the exemption was invalid either through interpretation or because it exceeded the authority of the SEC. I'll grant you, we leaned on the interpretation fork at the district court, but the arguments are largely the same, whether you're arguing against that it's a bad interpretation or that it exceeds the authority. It's the irrationality of the result. If you look at the arguments in our district court brief, they're basically very much like the ones here.
But counsel, let me ask you this. If there was not an overturning of the Chevron deference, would we even be here? This is now we need to take another view and determine.
We might be here. We might be here because the cases the cases that have upheld this so far are not in this district. So we might be here, but maybe not. It's hard to say.
And to that point, do you think it would be appropriate to remand to the district court to let the district court apply, deal with the issue under local right?
It's possible, Your Honor. I think this court ought to take it up on the merits, though. If Judge Arguello were to rule against us, we'd appeal it back up here, and I'm sure Master Fund would appeal an adverse ruling back up here. So for purposes of judicial economy, I think this court ought to just rule on the merits.
Well, on the merits, as I understand it, one of the considerations, maybe the primary consideration, is whether board-approved transactions involving a director by deputization pose an intolerable risk of abuse, right? Isn't that the...
I think that's a decent view of the standard, yes.
And who has the burden on that?
I think the SEC has the burden.
Well, you say in your brief we should use the ordinary tools of statutory construction to resolve that issue, but if we're talking about intolerable risk of abuse, I'm not really sure what the statutory, the ordinary tools of statutory construction
I guess you
would
have
be.
to-
Isn't this kind of laden with factual questions, a level of risk?
No, I think
Well, how are we, you're saying we should decide as a matter of judicial economy, how do we make that determination?
well, the SEC is only allowed to make exemptions that, for transactions not contemplated within the purpose of 16B. Consider what the purpose of 16B is and whether the exemption originally designed to allow compensation has any purpose being served by applying it to directors by deputization.
Well, adopting that interpretive lens and whether within the purposes contemplated by 16B, it seems to me that that leads, and correct me here, for a broad range of discretion by the SEC in determining what would fall within the purposes of 16B. I mean, how precise do they have to be in tracking or relating to the purposes? First question. Second, aren't they allowed some room for being over-inclusive or under-inclusive in determining what would be within the contemplation of 16B?
Your Honor, I think Loper Bright addressed this. It said that, vague terms are not enough, that unless there are explicit terms of discretion, such as in the judgment of the agency or as the agency finds, or sometimes a statute will tell the agency to define a term, those still are subject to agency discretion, but there's no such terms here. It says you got words of permission, they may exempt, followed by words of limitation, transactions not contemplated within the purpose of 16B.
The SEC the authority to make that determination, right? I mean, why
Only
is it
within,
this is-
only
is
within
this an
the
explicit
limits
delegation?
Congress set, Your Honor. Every,
And those limits would be the purposes of 16B, and then the question is, who's making that determination? I mean, if Loper Bright contemplates, and and it speaks in that footnote about one area where there's an explicit designation that you decide this, why is it that this?
I think that that's, because, Your Honor, it is the province of the courts to determine what the law is. This is what Loper Bright was all about. You don't just leave it up to agencies to say what the purpose of 16B is. That is the court's duty to interpret the statute and determine whether the SEC's action is within the bounds set by Congress.
That's true, but I won't take time to pull up that language from Loper Bright, but the language in effect is there's this range in which Congress has designated somebody to make that determination, i.e. the agency. Then the job of the court is to acknowledge that and to police the boundaries of that designation, which would mean that the court is going to have to make a determination within the context of the statute, is this contemplated by 16B or not? Okay, fine, we can do that, but presumably that means there's a whole bunch of stuff that the SEC can regulate where we shouldn't be in a situation where we're saying that it is within, not within the contemplation
But, Your
of 16B
Honor,
or not.
when the exemption is modified so as to allow large institutional investors who are privy to inside information access to the exemption, and the same shareholder without that not to have access to the exemption, surely you can say that that's irrational. That's just crazy. That's not the way the exemption ought to be. And I think it's this court's job to step up and say that to the SEC.
Point, it's not the way it should be is one thing. Is that how we view this? Do we decide anew this is not how it should be? Or do
Well,
we
you just-
decide whether it was in the context of the framework of their authority? Aren't those two different issues?
I don't think so. I think you determine that that kind of outcome was not within the purposes of 16B, which is to prevent this kind of short swing trading.
Use your time, counsel. I'll give you a little time in rebuttal.
Thank you, Your Honor.
Good morning, and may it please the court, James Tice on behalf of the appellees. This court may affirm the final judgment after a jury verdict on any of three independent grounds: waiver, the merits, or the statutory safe harbor. I'll begin with waiver. Judge Matheson, you're absolutely right that there's a waiver problem here. The summary judgment motion, as you pointed out, focused exclusively on the scope of the rule and the interpretation of the rule, citing our deference. It's about 1 page long. It does not invoke Chevron. It does not say that the agency exceeded its statutory authority in promulgating the rule. I will grant you that in the response to the summary judgment motion, which is about 5 pages long, the thrust of that, I think as my friend on the other side agreed, was on the interpretive form of the argument. The SEC got its interpretation wrong under our, and in fact cites our on the final page of that argument, but has a throwaway line essentially saying, or it also exceeds the authority. But again, that was not the thrust of the argument below. It was not.
Did the district court speak in its written order to the question of authority?
I think there's some ambiguity on that, Your Honor. I think what the.
Okay, there may be some ambiguity, but if there's an argument that the district court did pass on it, then we would not be in a range of forfeiture, would we?
I agree with that if the district court had clearly ruled on it, Your Honor, but I think what the district court said is that they have asked, the other side has asked us to overrule the SEC's interpretation. And then it cites a few cases, the Dreeling and Roth cases, which deal with both forms of the argument. They deal with the interpretive form of the argument as well as the excess of authority argument. So I think what she says in the footnote is they're asking me to overrule the SEC's interpretation. That, to me, sounds like the interpretive form. I think this is a waiver problem. I think, though, to zero in on the point a little further, this kind of shows why I think forfeiture is generally appropriate. We don't have a ruling below from the district court, as Your Honor noted. We have a footnote that deals with this very briefly. The summary judgment argument was only 1 page long. It didn't mention this at all. And so you don't have a developed record. You don't have developed arguments below. You also, crucially, don't have the SEC involved in this case. I think.
By the way, counsel, did you say anything about scope of authority in your initial motion for summary judgment?
It wasn't teed up, Your Honor. Yeah, I mean, we think the rule is valid. The SEC has said over decades that the rule is valid and applies to directors by deputization, so we had no basis in our summary judgment motion to opine on that. It was incumbent upon my friend on the other side to challenge the SEC's authority if that he was so inclined to do that.
You did not raise the question of authority. That was not within the scope of your argument.
It was not within the scope of our argument because the way the case was briefed and argued below was that if we were a director by deputization, then we should, therefore, the transactions are exempt. So we had no basis to
What's your position
challenge
on
that
the
authority.
Stipulation at the jury trial on the issue?
Yeah, well, that was, I think that's another good point, Your Honor. I mean, at the jury trial, after this issue had been resolved in our favor, the plaintiff stipulated that if Master Fund were deemed a director by deputization, that was the end of the case, that we were entitled to
Is there
the
any
exemption.
reservation or qualification on the stipulation?
There was not, Your Honor. When we made certain factual stipulations but wanted to preserve our legal argument, we did so. There was no such reservation here. It was a flat stipulation. If we lose on this issue, their exemption is triggered and the case is over. So I think that is just another independent ground to rule in our favor. But again, I do think it's prejudicial because the SEC was just not involved. I think if they had clearly challenged the scope of the rule, the SEC may well have gotten involved. I'm happy to answer any other questions on that, but turning to the merits, Your Honor, I think there's a few things that are important to emphasize. I think as we've discussed this morning, Congress expressly delegated to the SEC this task of carving out exemptions to the blunt instrument of Section 16. I think that's the way it's been described in the case law. Because it's a blunt instrument that takes the profit out of an entire class of transactions completely. The courts, including the Supreme Court, for example, in the foremost McKesson case, says that essentially it should be narrowly construed. We don't try to capture every potential short swing transaction. If there's any ambiguity whatsoever, I think foremost says it would be inappropriate to impose this harsh rule of liability when there's any ambiguity at all. And in light of that, the SEC has been given very explicit authority to exempt transactions that are not within the purpose of the statute. And I think crucially, for our purposes today, the purpose of the statute is to prevent the unfair use of information. I think that language by itself connotes some measure of discretion in determining what is unfair in light of the SEC's 80 years of experience interpreting the statute, and as the expert agency that is delegated the task of determining what transactions, even though they might literally fall within Section 16 scope, should not lead to liability.
If we were to dive into the merits of this, as Mr. Doherty is urging us to do, is it enough for resolution to look at the history of the statute and the rule, the purpose, and so forth, or would we need more information? In other words, in assessing whether a deputy by deputization exemption poses intolerable risk, how do you make that determination without evidence?
Well, Your Honor, I mean, that's a great question. I do think that ultimately this has been a clear delegation to the agency to make those calls. To your point, I'm not even sure how the court is supposed to determine what exemptions should be what exemptions should be created, because it's not a delegation to the courts to exempt transactions. It's a delegation to the agency to do so. So I don't actually think it's even an evidentiary question. I think it's a question of, did the SEC act within the scope of its delegated authority? To the Loper-Bright point, Judge Holmes, I think you referenced this language, but in cases like this, where the best reading of a statute, this is from Loper-Bright, is that it delegates discretionary authority to an agency, the task of the court is to recognize the constitutional delegations, which no one doubts this one is, fix the boundaries of the delegated authority, and ensure the agency is engaged in reasoned decision-making within that. And I think there's no question that we have that sort of reasoned decision-making here. They disagree, they think it's unreasonable, but I think my friend on the other side also suggested that there might, they have a range of authority. It might be rational to include or exclude certain transactions. So I think it has to be viewed through that lens.
Well, through that lens, I mean, you're right. The other side argued vociferously that it was irrational to have directors by deputization given access to that information, and managers don't have that information. Why is that not irrational?
It's not irrational for a number of reasons, Your Honor. I mean, I think just to begin, I think my friend on the other side mentioned and certainly conceded in his briefs that he's not even arguing that the rule exceeds the SEC's exemptive authority as it applies to sort of managing directors or human directors. So I think we only really then need to focus on distinctions between human and directors by deputization. So I think and human's a bit of a misnomer, because I think to answer one of your questions, you could have a human director by deputization if they put a deputy on a company's board. But focusing on that sort of dichotomy just for ease of this argument. So I think you really just need to focus on what the differences are. And I don't think there's any real differences that my friend on the other side pointed to. I think the closest difference they've come to of the 5 or so they mentioned is the fiduciary duty point, which is that a human director has a fiduciary duty. A outside shareholder may or may not have a fiduciary duty, probably does not. But I think what is crucial is that the deputy on the board, and this is what the SEC itself found, this is what the Roth case agreed with, the deputy on the board does have a fiduciary duty. And that fiduciary duty is important in 2 ways. Number one, it prevents the fiduciary from allowing the outside shareholder to benefit from sort of self-dealing or insider transactions. And number 2, it knowingly prevents the outsider from working with the fiduciary in such a way that would harm the company, and in that case would make the outside shareholder liable to the beneficiary. This is in the amicus brief, the Roth and Dreeling amicus briefs, I think on page, 34 and 35 of the 3rd appendix. I think it walks through some of those points. And I think that's really crucial because SEC itself recognized there are backstops here. Section 16 is a blunt instrument. It should be narrowly construed. It's supposed to take out a narrow class of transactions involving essentially market-based transactions on both sides where the risk is intolerably great. But there are other things, other laws, both state and federal, that that protect actual insider trading and self-dealing. You have state fiduciary duty laws, and importantly, you have Rule 10b-5, which imposes both civil and criminal liability for insider
And so
trading.
let me ask you about a couple of backstops in the rule itself.
Sure.
Which we're talking about an acquisition from the issuer. It's not a market transaction, it's from the issuer. And an acquisition that the board has to approve.
Correct, or the shareholders.
And that is, those are backstops that are supposed to protect against abuse of inside information. How does that work, though? I mean, that goes to the acquisition, but are there any protections about abuse of inside information when it comes to the sale? Because there, the board doesn't have to approve the sale, right?
Correct. Yeah, so, Your Honor, I think the way to think about this is that there are two transactions. What the SEC has said is that the initial transaction, the purchase from the board, just doesn't fall within the rule. There's no risk of unfair use of information in that circumstance during that transaction because the information is the same on both sides. So we can just put that sort of transaction aside. The second transaction in the market is the sort of transaction that the SEC was concerned, or Congress was concerned with Section 16. And that transaction can be matched against other market transactions that don't have the gatekeeping functions of that first transaction. But I think what the SEC's point was, in this sort of, we can exempt this sort of class of transaction because they don't involve unfair use of information, given sort of parity of information, given that the board of directors controls the timing of that acquisition. It's not a situation where a director can pop into the market and take advantage of market-based participants, and also because of the fiduciary duty.
But on the sale side of the transaction, no board approval for that.
No board approval, Your Honor.
That would apply also to directors
Correct.
themselves, right? If they've had board approval for purchase from the issuer, they don't need board approval for the sale either. So the director and director by deputization would be treated the same?
Right. Yes, that's correct, Your Honor. But that's true. Again, I think that goes to the point I mentioned earlier, which is that problem that my friend on the other side mentioned would apply to both human directors and directors by deputization. So it's not a reason to hold that this rule is irrational with respect to directors by deputization. And what the SEC said on that in particular, and again, the Roth and Dreiling, or Dreiling, I'm not sure how to say it either, go into this in some detail, is that there are both those state and federal backstops we're talking about.
You're talking about 10b-5 on the federal front?
That's right.
Because what I want to understand is, I understand how the timing issue would sort of mitigate against one unfairly using the information in the market. But on the parity of information front, that really relates just to the purchase, right? Because the insider is still going to have information that the market doesn't have when they sell, right?
Not usually, Your Honor, and not in this case. Perhaps not ever, because in this situation, for example, there was a purchase about 5 months, like in October 2019, and about 5 months later in March, there was a sale. But the purchase happened, according to the terms of the agreement at that time. The sale 5 months later occurred only after, first, the COVID pandemic started rearing its ugly head, and number two, that good news about the company became public knowledge, which is that a test was going to have exclusive rights through this company. And that caused the share price to rise. At that point, there was also informational parity during the sale. So that's often going to be the case as well. This is not a case where, for example, the director purchased, the outside director, the shareholder, purchased stock from the general public when it was very cheap, knowing that they were going to get this special exclusive marketing arrangement. That would be the sort of unfair in and out quick market transactions that Section 16 was designed to prevent. That's not what's going on here. I think one other,
Is it something that could go on here? I mean, what I'm trying to get at is, because we're talking about the rule, we're not talking about what happened in this particular case.
Of course, of
And
course. I was just
so
trying to provide.
I'm just trying to understand the informational parity issue. Why wouldn't the director necessarily be at an advantage vis-a-vis the market when they go into the market and have information? And let's assume, again, not talking 5 months down the road, let's assume I purchased the shares from the company as a director by deputization or a managing director for that matter, and I immediately turn around thinking that I have a sense from the information I have that, you know, things are either gonna go up or go down, and nobody else in the market has that. Why isn't that a conceivable possibility?
Well, again, I don't think it is the sort of possibility that the statute is concerned with. There are other statutes that deal with actual insider trading, with actual use of insider information. Here, there was two transactions. I mean, in general, there's going to be two transactions with equal market information, a purchase between equal parties and then a sale between equal parties too, because at that point, again, you're only selling because the information is now known to the market. And so, again, I just don't think it's just this class of transactions the SEC determined in its expert judgment does not fall within the scope of the rule.
Just to follow up on Chief Judge Holmes, would the situation be different? Would there be other protections? I understand the underlying facts in this case. The information went public and then there was the public sale. Would it be different if the public sale happened before the information became public? And are there other protections for that?
Yeah, so I think what the SEC has said about that is, yes, there are other protections. There's self-dealing restrictions through state law, and there's insider trading protections through federal law. But I think one other thing the SEC has emphasized over and over again is, again, because Section 16 is this blunt instrument and it imposes liability without fault, it's both under and over inclusive, that it's not supposed to prevent any possibility of speculative abuse, only intolerable risks of speculative abuse, not any use of information, but unfair use of information. So again, I think the SEC was well within its discretion to say this sort of class of transaction, for various reasons, it's not the sort of transaction we're worried about and we're going to exempt. I know I'm out of time. I just wanted to mention one final point on the safe harbor, just because I think I'd be remiss if I didn't mention it. I just think that is another way to resolve this case. It's very straightforward. We invoked this exemption in our March 2020 filing. That was Exhibit 40 in the docket below, filed the sale of the shares in March, and at that time noted that Master Fund was a director and said that the transactions in question were exempt. There's testimony about this at ECF 179, pages 288 and following. I think if there's any doubt about any of these other issues, this clearly falls within the safe harbor. I don't know what it would mean to rely on a rule in good faith if it were not invoking it at the time of the supposedly liability-creating event, before there was a demand letter and before there was any litigation. Thank you very much.
Yeah, on that last point, they claimed to be a director by deputization at the time of the sale, when they needed the exemption. At the time of the purchase, they claimed they were non-exempt purchases on their public Form 4s. So the reliance under 23A reliance is simply not tenable. Read Green v. Dietz. The court there established a but-for test for 23A that the transaction would not have taken place. That means the purchase transaction in this case, but for the reliance on the exemption. I'd like to say something about Judge Matheson's questions about the follow-up sale. Yeah, when you grant an exemption, what is happening is you're giving permission to sell. If you're not going to sell, the exemption's irrelevant. You don't need an exemption if you're not going to sell. All right, so to just look at the information, the relationship between the issuer and the insider at the time of the acquisition is incomplete. That's not the purpose of 16B. The purpose is to keep them from reselling them within 6 months, which is what happened in this case. And it happened within an hour of the press release that disclosed this. Market shoots up. They dump all their shares in one single day, okay? Now, can we prove that there's insider information? No, because we didn't need to. But it's fair to say that the market thought more of this COVID test announcement than Master Fund, who had a director on the board. You know, maybe he didn't believe it had legs, this price increase. And so they jump on it and they take advantage of the jump. The public thinks it's great. Master Fund, not so much. Why would you be selling everything you got in one day? On the jury instructions, we made those stipulations for purpose of narrowing what the jury had to determine. That was not a concession of the legal issue in this case, so I reject that. On narrow construction, defendants love to cite narrow, that the court saying that this 16B should be narrowly construed, but they don't get it right. What the Supreme Court says is they're not going, Your Honor.
I gave you 2 minutes.
What the Supreme Court says is we're not going to go outside the bounds of the language of the statute. For example, in Reliance Electric, the plaintiff wanted to match transactions more than 6 months apart based on the fact that they were planned within 6 months. Supreme Court said, no, that's outside the statute. This is a remedial statute, so we're not going to, give it this broad, woolly construction. But when transactions meet the criteria of 16B, courts have insisted on vigorous enforcement.
Case is submitted.
Thank you, Your Honor.
Thank you, counsel. Thank you for fine arguments. The next case that we'll hear
And if that's the worst that happens today, we're okay.
All right, the next case this morning will be 25-1113, Garrison Property and Casualty versus Horton. Counsel for Appellant. I understand you're going to try to split your time. Is that right?
We're going to attempt it.
Okay. We make the first counsel for Appellant. We make your appearance.
May it please the court. Good morning, Your Honors. My name is Michelle Cortez, and I represent Appellant Nicholas Horton. Let me explain the injustice that occurred in this case, which we asked this court to remedy. The district court rewarded USA and Garrison for their egregious conduct when it granted them summary judgment, finding no conflict between exclusion B1 and the non-owned vehicle exceptions. That was error. For this contention, the district court claimed the non-owned vehicle exceptions only pertain to ownership and use. But that's not true. There's 5 factors under the non-owned vehicle exceptions: ownership, use, family member, that it be primarily insured by another carrier, and most importantly here, and what the district court ignored, is that it be a vehicle. Now that term vehicle was chosen by USA and Garrison, and it's a very broad term. They also chose not to define vehicle, even though they could have. So when we give effect to the term vehicle, as the district court should have done, that shows the conflict in the policy. So what is the conflict? Exclusion B1 avoids coverage for a vehicle, which all parties agree is a motorcycle, includes a motorcycle. So exclusion B1 avoids coverage for a motorcycle not listed on the declarations. But the non-owned vehicle exceptions restore coverage for a non-owned motorcycle not listed on the declarations. Those provisions conflict, meaning they're internally inconsistent, and under established, long-standing Colorado law under Simon, Neeson, Collard, and Worsham, the conflicting exclusion must fall and the policy must be construed in favor of coverage for the insured here, Horton. This is supported by USA and Garrison's own interpretations of coverage. They had an adjuster who said, we are affording coverage. They had in-house counsel that said that there is coverage under the non-owned vehicle exceptions. They even certified to the Colorado Insurance Commissioner that they were expanding their policy to provide non-owned vehicle coverage. That is their own term, non-owned vehicle coverage. So this is consistent with Neeson versus State Farm, in which the court supported its finding of coverage by State Farm's own interpretation, finding coverage for the other victims of the crash.
However, were not the provisions that led the court to believe, the Colorado Supreme Court to believe that there was a basis for confusion, they both related to warranties, right?
Sort of, Your Honor, but it wasn't that clear when you look at it on its face. So there was an exception restoring coverage for warranties. Then there was an exclusion for what's called completed operations. When you look at that on its face, you may not think those provisions conflict. It wasn't until completed operations was defined, which is defined as in part warranties, then you see the conflict between warranties.
I'm sorry, go ahead, Judge Hobbs.
Would you agree in that case, the court found that that was a conflict that was irreconcilable?
Correct.
Is it your position that the issues here, the conflict that you're raising is irreconcilable, meaning that the various exclusions and the exceptions, there's no way to read those in such a way that there's not a conflict?
Correct, Your Honor, because they both
Hey, with regard to exclusion B1, why wouldn't they put the same language in the exception to B2? And why does it say on the exception to B2, why does it specifically say with regard to exclusion B1? And the same with B3. It says the exception with regard to exclusion B3. I mean, it says that specific language in those paragraphs, right?
let me make sure I understand the question. That the exception to B2 says this exclusion does not apply, and then the B2 language. The only thing I can understand about that is that these exclusions and exceptions were added to the policy at different times, and so there's different language. But there's nothing in the policy that says that B1 controls B2.
Which is set forth in B2, you're trying to apply that to B1, right?
Incorrect, Your Honor. That is a red herring that USA and Garrison have raised. Those are just exceptions under B2 and B3. The issue is, do they conflict with B1? Because the policy language does not say B1 and B2 and B3 have to be met. There's no word and between them. Adding that word.
And for the exclusions either. You have one exclusion, you're excluded, right?
Correct, but under Colorado law, if they conflict, and this is something that is unique to Colorado law, it is a cornerstone principle of insurance law in Colorado. If they conflict, the one doesn't still control. The conflicting exclusion falls. So in this case, because the exceptions to B2 and B3 restore coverage, and because they conflict with exclusion B1, B1 falls and does not control, and coverage must be construed in favor of the insured Horton.
If the exceptions to B2 and B3 apply to B2 and B3, what is the predicate for the conflicting basis? I mean, what's the conflicting basis? If they apply to their provisions, I think that's what Judge Heil was talking about.
The problem with the district court, the problem that I think the district court had was that it was an overgeneralization of what the exclusions were about, but it was not a full analysis of all the factors.
In B1, do you agree that a motorcycle is excluded from coverage?
That's correct, Your Honor.
So the issue is,
If it
how
wasn't
do
on
the
the deck.
exceptions in B2 and B3 change that?
If it wasn't on the deck sheet, it was excluded from coverage, and that is a key provision. Now, B2 and B3, which were added later, which make the policy internally inconsistent, restore coverage for a non-owned motorcycle, not just a motorcycle, a non-owned motorcycle that's not on the deck sheet. So because the non-owned motorcycle is restored that's not on the deck sheet, that conflicts, and it makes...
I was trying to get at earlier. It seems to me that Simon was dealing with apples and apples. Here, you're not dealing with apples and apples. B2 goes to, the distinction B2 draws is on ownership. The distinction B1 draws is on the nature of the vehicle. And therefore, whereas in Simon, they were both dealing with warranties. So one could read into that a potential for confusion. Here, you've got B2 and 3 talking about the basis of the vehicle ownership, B1 talking about the nature of the vehicle. Why would there be any basis for conflicting understanding of those?
Answer this question, then I probably need to sit down. So the term that is the key here is the term vehicle. There is no restriction on the number of wheels of that vehicle under B2 and B3. Now, they could have said, we restore coverage for non-owned cars, or they could have said, we restore coverage for non-owned autos and define that as a four-wheel car. They specifically chose non-owned vehicles and certified vehicles to the Colorado Insurance Commissioner.
Conflict exists in the fact that B1 talks about vehicles and the word vehicle appears in B2 and B3?
And the issue of it not needing to be on the deck sheet, Your Honor.
Issue with regard to, how does reliance play into this?
How does reliance play into this?
Reliance on that conflict?
Your Honor, I think that the conflicting interpretations of USA and Garrison over many years show that they did not know how their provisions operated together. And I understand that Ms. Abeyta relied on USA and Garrison's representations when she filed suit against Horton regarding coverage.
But I mean, the record is pretty clear that Mr. Horton didn't rely on that.
Mr. Horton relied on USA and Garrison being upfront with him and treating him as a quasi-fiduciary, which they did not when they didn't raise coverage timely. For 5 years, USA and Garrison didn't raise coverage, and that is prejudice as a matter of law. And I apologize for stuttering. I'm just worried about the time. If I could pass it over. Thank you.
Good morning, Your Honors. Michael Rosenberg here on behalf of Tashira Abeyta. March 13th will be the 8th anniversary of this horrible motorcycle crash. I did want to acknowledge in the front row that Tashira's mother and sister both came so they could be here to watch these proceedings today. Our issue, real quickly, I think it's laid out in the briefs. We do believe that the policy is at best ambiguous, which is reflected by the fact that USAA's own legal department concluded there was coverage. They offered the $100,000 unconditionally when we got into the case. We got into the case, a year and a half after those settlement opportunities were already gone.
And so the idea that you could not raise an exclusion until 3.5 years after the accident, and one that you didn't raise before, is just contrary to every Colorado case there is. And the Lyra case, I did want to say, is a completely different animal, because the Lyra case, which says an insurance company doesn't have an obligation to consider punitive damages.
So could I just,
Sure.
time is short, so let's focus in a little on a question. Your brief indicates that the common law bad faith claim is based on the company's failure to settle, and then, of course, the resulting excess judgment. Is that an accurate statement of your argument?
Well, I don't believe that encompasses all of our argument. The investigation and the lack of one.
Where did you talk about that?
It's talked about throughout all of the briefs.
Did you say that?
That
Because most everything in your brief is about the settlement.
we talked about the investigation, Your Honor, and forgive me, I do want to give the time back to Ms. Cortez.
Well, this
but
is a question that I think we need to have.
It's in the brief. He did not investigate the question of ownership, Your Honor. He didn't investigate it, and then when he was told it, this is Todd Ellis, he was told he doesn't own the vehicle.
Yes, then we need to move on. The appellees say that you cite no authority that holds an insurer owes a duty to settle a non-covered claim, and I'm just quoting from their brief on that. Is that true?
No authority that a duty,
Authority.
it's a
cite
red
no-
herring because
You cite no authority that holds an insurer owes a duty to settle a non-covered claim.
I would agree with that, and it is a red herring that doesn't mean anything, Your Honor.
Non-covered claim, then what happens to your
Insurance
argument?
companies settle claims every day without knowing whether they're going to be covered or not.
To the question, assume the claim is non-covered. Is there a duty to settle? And do you have any authority for that?
If you can assume it's non-covered, which they could not do, so I reject the hypothetical, I agree. I agree.
Counsel, you don't disagree with the
No,
question.
I just agreed with you.
What's the answer? Is there a duty to settle a non-covered claim under Colorado law?
If that claim is non-covered and that's been determined, or you properly and timely reserve your rights.
Time frame. When does the duty attach in the context of the settlement situation? I mean, if the claim absolutely is not covered, that's one thing. But at the time that they rejected the offer to settle, if the knowledge they had did not indicate it was not covered, what is the implication of that for Colorado law?
What Colorado says by statute and from the Trimble case forward in every single case, including the Arellano versus Cruz case that I attached as supplemental authority in every single case, the question is, would a reasonable insurer act this way? And if not, did it cause damages?
When is what I'm saying. Does timing matter?
Timing's everything, yes.
And
when it comes to this,
for purposes of law?
To this, timing is absolutely everything. That's why we have rules about raising raising coverage defenses within a reasonable time. It's to prevent this very case of what happened. I don't think anyone should be okay with what happened and excuse what happened here. And I think it's sad. Thank you.
All right. Cases, counsel, we'll hear from you.
May it please the court, Jeremy Mosley on behalf of Appellees, Garrison, and USAA. This case is about two auto policies that plainly exclude coverage for a motorcycle. As you heard, it is undisputed that exclusion B1 in the policy excludes coverage for a motorcycle.
Clarify for me, Mr. Mosley, however, what this question that I was trying to tease out relative to the common law bad faith claim. At the time that Ms. Abeyta sought to settle, at the time that those settlement conversations were going on, it's my understanding that the light of B1 had not shown itself in this case in terms of its ability to exclude coverage. So my question is, when do you judge this duty of common law bad faith? And to put a finer point on it, if at point A, discussions occur in which somebody says, I'm ready to settle, and it is unclear, or it appears that there may be coverage, and the insurer denies it. Point B, a year down the road, the insurer knows that there is not coverage. When do you judge their common law bad faith?
Generally speaking, Colorado law says that you judge their conduct based on what was available at the time. But you still have to have a duty that arises. And if there's no covered claim, there's no duty to settle.
You
The
judge
thing
their
to-
conduct, you judge their, well, I'm talking about the duty now to act, to settle. And what I'm saying is, do you measure the duty by what they knew at the time? That's what I understood you to say. And if that's true, what did you know at the time that this settlement was going on that would have allowed you to, in good faith, deny the settlement?
So a few things. First of all, there's a difference between whether a duty arises and if there is a duty, how that's measured. So that's why I say that the good faith, or how your conduct is measured based on what you knew at the time for the claim, but the duty doesn't arise if there was no coverage at all. So that's the distinction that matters first under Colorado law.
Does that mean no matter what the conduct at point A, as Judge Holmes said, and then later it's determined that there's no coverage, is that just retroactive? It wipes away what would otherwise have been bad faith?
It depends on the damages alleged. There still have to be damages flowing from that alleged bad faith conduct.
That there is a claim that there are damages, and Judge Heil stated it more elegantly than I could. That's the point. Does it retroactively, the fact that you later learn there's coverage, does it retroactively, let's assume that you acted in bad faith. I'm not making a judgment on that. Let's assume you acted in bad faith at point A, and we later find out there was not coverage at point B. Are you absolved from that bad faith at point A?
If the only damages alleged are a failure to settle, and there was never a duty to settle, then there is no actionable conduct that can be tied to the damages being claimed.
Claiming damages.
But the only damages they're claiming is an alleged failure to settle, and there was never a duty to settle because there was never coverage.
No. The coverage issue, I thought we were talking about as being discrete. The question of whether you ultimately had to settle, okay? Whether there was ultimately coverage. You're saying that in that moment in time, when that settlement conversation was going on, why could the argument not be that you acted unreasonably in that moment in time and not settling based upon what you knew at that time?
At the time, first of all, because you also asked this as well, what is the evidence? In Volume 6, page 1045 in the record, and around there are the letters that USAA sent and Garrison sent, saying from the outset that there was no coverage. And because there was no coverage, they would not pay the claim. They say that this motorcycle is not insured by USAA or Garrison. They said that in the letter.
Where did those letters arise? I mean, is this
They-
after the lawyer communicated the information about B1? What are we talking about now?
We're talking about from the beginning, October of 2019, when Abeyta's counsel first raised a claim. The response was to say, our position is there is no coverage. It's not a listed vehicle.
At that time, it wasn't because of B1.
They did not cite specifically to B1, but they cited to, well, first of all, their initial was to talk about potential UIM coverage based on the other driver's liability. They also then said, even for liability coverage, it wouldn't be covered because it's not listed, it's not insured under these policies. They subsequently cited to B2 and talked about ownership, which ultimately correctly applied to one policy, the USAA policy, and not to the Garrison policy for Nick Horton.
regard to Judge Mathis's question, because I ask it in the context of a duty to settle, so to speak. But let's just say that there's no reasonable investigation. It's just not done, for whatever reason. Or it was sloppy. And then later, years later, you find out that there's no coverage based upon an issue that was really never raised. Does that retroactively wipe away any problems with the failure to investigate?
It depends on the damages alleged.
Because the duty to investigate is a separate duty, right?
Yes, but it rises out of the contract.
What's your
And-
position on whether the claimant preserved a failure to investigate claim? Is that an issue here?
It's not, because what they've raised instead is focused on the duty to failure to settle. And here's the key. In the abstract,
Could I
Can
just-
there
Could I
be-
just jump in, because I've got to follow up on that answer? Do you say anything about waiving that issue in your brief?
well, no, we argued instead what they focused on. Their brief focused on failure to settle, so we responded to that.
Did you address the unreasonable investigation question in your brief?
What we've addressed, and this is what ties it all together, is the damages being alleged. It's not enough to just say I was damaged. You have to say, what are your damages? They did here. It's undisputed. Their only damages are the excess verdict that flows from a failure to settle. Here's what matters. Horton is the insured who the duty was owed to, if any duty was owed previously in the claims handling. Horton testified that if he had been consulted about those demands being made, he did not have the money to make that claim or to make that payment. He also testified he would have simply told Garrison or USAA that they should make the payment. What that turns back to is he's telling them that they should have made a payment for an uncovered claim.
Asking you what you put in your brief, okay? Did you argue against against any claim for unreasonable investigation? Counsel says it's all over, that it's all preserved. And my question is, I think you just answered that you don't think it is, but did you waive the waiver by addressing it in your brief?
No, because what we addressed in our brief was what they raised, and that's what I'm trying to put together, is the focus entirely of their arguments is the failure to settle.
You've answered the question. Thank you.
What I'm struggling to understand is why could not damages flow from the failure to settle? And if your answer is because there was no coverage, that seems a very incomplete answer. I mean, if the issue is that there was an excess judgment as a result of your failure to settle based upon the information you knew at the time, and let's just assume that you were unreasonable in not settling at that point in time, and because you didn't settle at that point in time, what we ended up with was an excess judgment. Why couldn't damages flow from that excess judgment?
Because the duty to settle arises from indemnity. And if there is no coverage, there is no duty to settle. That's the principle that the Lyra Court, the Colorado Supreme Court and Lyra v. Shelter made very clear in distinguishing between compensatory damages in that case that were covered and punitive damages that were not covered. What the court said is this: if the insurer has no contractual duty to indemnify the insured for punitive damages, the insurer has no tort duty to settle in good faith with regard to those damages.
Is this answer to Chief Judge Holmes in effect saying it didn't matter what they knew about coverage during this settlement, this key settlement period? All that matters is whether there in fact was coverage?
On the issue for a duty to settle, correct. It doesn't matter what was known then, because you have to have the duty that arises before you apply the test of whether there's bad faith. The duty does not arise on a claim to settle that claim when it's a non-covered claim. And what was known at the time was that it was a motorcycle, ownership was initially questioned, and that there were multiple exclusions that applied.
But let's say during the settlement period, the company thought there was coverage, even though under the policy maybe there wasn't. Let's assume there wasn't. Once you look at the policy and study it, and we can argue the exclusion, the exceptions and all that. But let's say that at the time, they thought there was coverage and then didn't settle, and then we have the excess judgment. Are you saying that doesn't matter? What really matters is just whether there was coverage?
When we're talking about a duty to settle, that is correct. What matters is whether there's coverage. That's what LIRA says. No duty to settle arises for uncovered damages.
Answer the same with regard to the duty to investigate, though. Is your answer the same? If there's no coverage, then that retroactively wipes away any breach of a duty to investigate?
It depends on what damages are then alleged. And that's why I referred to what Horton actually said.
Your answer is different on that. But it's still, you still have to show damages, but your answer is, if there's no coverage at the end, that doesn't wipe away your obligation to investigate reasonably. Is that correct?
That's correct.
Okay.
But you then have to show what actual damages are tied to that. But
Recoverable damages, and why weren't there recoverable damages here?
well, for example, when you have a non-covered claim, this is why Horton's testimony matters. It's one thing if Horton said, had I known about that offer at the time to which you were saying there's no coverage, I would have paid that claim. I would have entered that settlement. There are other courts in other
If they
states
assert
that apply that standard.
there's no coverage early on because they investigate it, and they show that there's no coverage, the case probably doesn't even go to trial, right?
Well, not true, because they actually did investigate it. They said there was no coverage, and they
Well,
kept coming back.
I mean, no coverage on exclusion B1.
Well, but that's, I mean, we're hearing today that that's not even true, because the other sections provide coverage. They were sent a copy of the policy in the middle of this, the liability section of the policy, and they still proceeded with making this claim.
It's in the record where adjusters or counsel or whatever says there was coverage. What do we do with that?
Well, I mean, first of all, that's evidence that isn't relative to what their actual damages being claimed are, that tie back to the fact that there had to be a duty to settle for us to pay benefits first. The second thing is, those specific documents were asking a single question. Does B2 apply? They weren't even addressing B1 in those documents. There are other documents that address B1 where the adjuster went and got a coverage opinion, and then after asking about B1, issued the reservation of rights letter. So they're being overread to claim that that meant there was coverage under the policy.
And I thought that B1 surfaced because the lawyer told them about B1,
No, I mean,
that lawyer.
oh, no, actually, the timing of that is incorrect. They had previously, before Wheeler Trigg was involved, had already requested a coverage opinion from a different law firm, Sweetbaum and Sands. So while that's what Abeyta claims in the record, that's not what's supported by the facts. Volume 12, page 1806, you'll see Wendy Boyd testifies that earlier in August, they were already requesting this coverage opinion, completely separate from Wheeler Trigg, because Wheeler Trigg's on defense and they weren't looking to them for coverage at all. They were looking to a coverage firm.
Was the first information you received about B1 from Wheeler Trigg?
No, it was not.
Let me ask you a question that.
And it can't have been
And
because of that
I
timing.
understand this is a difficult question, but what is your position or your client's position on whether or not the claim was initially properly and reasonably investigated? What is your position on that?
That it was properly and reasonably investigated and determined there was no coverage, and that held up, that there was no coverage. And Colorado law is also clear that you
On
can't
whether-
create coverage later.
Whether the
by a
claim
stop.
was properly investigated and timely investigated with regard to the reason there was no coverage, meaning ultimately B1. What's your position on that?
From the outset, the letter said it was not covered as a result of not being insured under the policy and not being listed on the policy. And that is part of what B1 says too. I believe that there was sufficient information presented from the beginning as to what the ultimate coverage exclusion used that applies is. And because Colorado law is clear that you can't create coverage by estoppel, that same idea still applies, that just because you mention one exclusion and don't mention all the others that could also apply, doesn't mean you can't raise them later, and it doesn't mean you acted in bad faith by doing that either.
Go off track because there was a mistaken understanding that Nicholas owned the motorcycle and not the dad.
That was one thing that he was relying on the adjuster and focusing on that exclusion when ultimately it applies to one policy and not the other.
relevant to whether the investigation was reasonable?
Because the only damages that have been alleged as a result of that are to say we should have gone ahead and paid a claim that was not covered. It's not tied to any other conduct and damages. That's the fundamental problem that the district court recognized, and that's why it should be affirmed. Thank you.
30 seconds.
Your Honor, there was an issue about the Wheeler-Trigg opinion, and that goes back to the reliance question. There was reliance from Mr. Horton because he relied on retained defense counsel to act in his best interests when they went behind his back and issued this coverage opinion adverse to his interests.
He said he wouldn't have done anything differently, though, didn't he?
Your Honor, he had no right to handle the claim. If he would have been able to handle the claim, maybe he would have been able to do something differently. But he had no right to handle the claim, and so that's boxing him in on a legal argument. He couldn't pursue that avenue. And one last thing,
Answer the question, do your damages stem from anything other than a failure to settle?
Your Honor, our damages stem from the unreasonable conduct, the excess judgment, which is prejudice as a matter of law.
Which relates to the failure to settle, right?
And it relates to emotional distress, having to go through the underlying trial, emotional distress from the deck action. The reason why we're in this deck action is because Wheeler-Trigg issued that opinion adverse to his interests. And the last point is, there was a letter that USA and Garrison sent to Horton right after he was sued, affirming coverage under the policy, which he did rely on that there was coverage.
Another question. I'm going to ask you the same question I asked opposing counsel. So basically, I said, well, if they would have asserted B1 initially, maybe the case doesn't go to trial. But your position sounds like it would have went to trial anyway if they didn't settle, because you would have taken the position that you're taking now, that there was coverage under the exception to exclusions B2 and 3, right?
And let me make sure I understand the question. If they would have properly raised B1, would have it gone to trial?
Well, would you have said, wait a minute, there's no coverage? I mean, the case goes away, essentially.
I think Horton would have informed Abeyta. The insurance companies are saying there's no coverage.
Well, that's what they were saying. But what would the position on the other side have been? Well, there's still coverage under B2 and B3?
I think it raises a reasonable coverage dispute, and then there's a question from Abeyta whether to even pursue the claim, because this accident happened in 2018. Mr. Horton has been fighting this since 2018, and it's taken years of his life. And there needs to be an analysis, and there is an analysis by plaintiff's attorneys. Would this be reasonable to pursue this? And in this case, we've been told they wouldn't have pursued it because it would have been a protracted fight. But since they denied it on a false basis, Abeyta thought, oh, there's definitely coverage. We're going to file suit against Horton, and Horton got roped into this. Thank you for your time, Your Honors. Appreciate your time.
I know there's some family members here, and I know this is all hard to hear, and I know it's a terrible tragedy under any circumstances, but I'm sorry for your loss. We're looking at this on legal issues, and that doesn't impact your loss either way. I understand that, so let me just say that.
Okay, thank you.
Submitted. Thank you, counsel. And we'll take our 10-minute break now.
We'll return at 11. Did all get water just mopped up? Thank you. Right here. Ask you to pull that door behind you when you come in. Thanks. Honorable Judges of the United States Court of Appeals for the 10th Circuit.
Please be seated. Next case this morning is 25-1157, Lingam versus Dish Network Corporation. Counsel for Appellant, if you'd make your appearance and proceed, please.
May it please the court, Christopher Jackson on behalf of the plaintiff's appellants. In this securities appeal, the district court erred when it granted the motion to dismiss because it misconstrued the challenge statements and took inferences in the defendant's favor. I'd like to focus on a couple of the key false statements. And the first set are those that we identified as statements number 1 and 5 in our chart. Those are the ones that Dish completed a successful field validation of the 5G network. Those statements are false because Dish did not complete a successful field validation. It only sent one text message, and it didn't send data or voice or any other essential attribute of the network. And there are a few reasons why the district court erred in concluding otherwise. The first is that this is precisely the kind of factual allegation that must be taken in the plaintiff's favor at the pleading stage. The allegation, that is, that to a reasonable person, the phrase successful field validation isn't just sending a text message. It isn't just validating one attribute of the network, but all of the core or essential attributes of the network.
Does a reasonable person know that, or is that something that requires some kind of expert testimony?
I think it's true that a reasonable person knows it. Expert testimony would certainly be some evidence that, past the pleading stage would be relevant in assessing that decision or that fact.
Some issue in your briefing about the word A. The word A was added to a successful field validation. Tell me about how that came about, because initially you said that was added by the district judge, and it wasn't in the actual text. Was it in the actual text?
I believe that the word A was, and I think there was a different clause that the district court added in the decision below. So it's true that the statement we're challenging, it says a successful field validation. And the reason why that would be false no matter what is that if a field validation means that you're validating all of the essential attributes of the network, saying A, putting it in the singular, that just means how many times did you do the validation? You still have to, if it's true, as we're saying, that field validation means validating everything, you've still got to validate everything at least once. So the fact that it says a field validation, I don't think that changes the question or the issue. Turning, I think, to that other point about what the district court added in its order. So what the district court said, and this is on addendum page 7, it said, quote, that the test was a successful field validation of a network functionality, namely text messaging. And it's the phrase of a network functionality, namely text messaging, that is not in the statement that we're challenging, and that fundamentally changes the statement's meaning. It goes from a field validation to a particular, more limited scope of what a field validation would be, a network functionality rather than all of the core or essential functional attributes of the network.
Is that what the statement says too? I mean, this field validation, is that defined anywhere? What does it even mean?
So it's defined in our complaint.
Okay, go ahead.
Sure, Your Honor. On page 70, so we make just the factual allegation that a reasonable investor would understand field validation to mean what we're saying it means. Also in paragraph 70, we allege that confidential witness number 2, who's part of this industry, that the confidential witness also understood, like that it was their understanding as well that in the industry, successful field validation means all of the attributes in the network.
Does that mean that a reasonable investor would understand the statement to be saying that the 5G network was fully functional?
So I don't know if that's right. So yes, to a reasonable investor would understand what it is that we're alleging. I'm not sure that we're alleging, I don't think we're alleging that the statement was it was fully functioning. It was that it was a successful field validation period. So arguably, the phrase fully functioning might mean something greater or something different. Our challenge is limited directly to the statement of these.
Do we have to accept the meaning of a sentence or a phrase because you allege what it means in your complaint, or is it more a matter of this was the statement, And then at that point, some determination has to be made as to what it means. But just because you allege it means something, is that something that at this stage of the proceedings, we just have to accept that?
I think in this case, with this example, yes, that's a sufficient reason to overturn the district court, because the particular phrase we're talking about, a successful field validation, our inference is reasonable, or our interpretation of it is reasonable. If we said a field validation meant, something not in the field, that actually the words field validation meant something entirely different than those particular words meant, then I think the court can look to dictionaries, it can look to other items that it might take judicial notice of, and I think those are all fair arguments if the phrasing were different.
You're saying your interpretation is reasonable, but isn't what we're talking about whether it was false or misleading? Well,
Correct.
Those are two different things. I mean, to say something is false, I'm saying it's a green light. No, the light was red. The notion that a successful field validation, you define what field validation is in your complaint, and then you say they didn't do it. Well, how does that work? Why do we have to accept, going back to Judge Matheson's point, why do we have to accept your definition of what that means?
I think a couple of points, Chief Judge Holmes. So it's true that we say our inference is reasonable, but our allegation is reasonable about what it means, but our allegation is that it carries only one meaning, that in the telecommunications industry, if you are a senior executive reporting to the general public and saying, we're building a 5G network and we completed a successful field validation, that the only thing that means, the only assertion that it's making is that it was a validation of not just, pick a function, any function you want, but in fact, all of the essential attributes.
I like that assertion, but the point would be, what facts did you plead to support the notion that that is the only meaning that it would have in the industry? You refer to one confidential informant who understood it to be that way, but if that's all you got, it seems to me that's not a lot.
So I suppose disagreeing with that last provision, I think that is a sufficient reason, but there are other allegations that we've
One
included.
confidential informant who says this is my opinion, this is what I understand it to mean in the industry is enough?
Well, so we do have other items, and I want to get to that in a minute, but to answer your question, yes, I think in this context it would, because again, a successful field validation, if you have, this bleeds into the other arguments we have. So this is also the context of the statement that matters. What you have is senior executives of DISH who are reporting to the public, and they are talking about this make or break effort on behalf of DISH to build out a 5G network. This was the pivot from paid satellite TV into something entirely different. It was a make or break. It was the core operation of the company. And they were saying, we're putting all of our eggs in this basket. We're building out in Las Vegas first. And we can happily report to you that we have finished a successful field validation and that we will commercially launch for enterprise customers in just a few months. And then after the fact, the other false statements that we allege, they continue to talk about the fact that they are making good progress. In that context, I don't think it is reasonable to infer that successful field validation means we just picked one attribute of the network. We in fact, we know, like what we allege in our complaint is that the defendants knew when they made the assertion that there was a successful field validation, they knew that the network had no VoNR, no voice over network capabilities, and that it had no ability to transfer data. So what they knew is that they had a 5G cellular network that could not take cell phone calls and that could not transfer data, do things like sending emails. And they were reporting to the public that it was a successful field validation. And I think particularly in that—
So they didn't say anything about voiceover or phone calls, but your position means that a successful field validation has to include those things or it's not a successful field validation. Is that your position?
Yes, for a 5G network in particular, yes. And because that is an essential or core attribute of the network, which I don't understand the defendants—
Other than a confidential informant saying this thing, is there something else in the industry? Is there some recognized industry published piece that tells us that?
Nothing in the complaint, and I think—
Disagree on that?
I think experts often disagree in district courts, but I think, to piggyback off of Chief Judge Holmes' question as well, these are the kinds of questions you can have an expert talk about that maybe a person—
Is it a term of art in the industry, successful field validation?
I think it's true that it has one meaning. I don't know, term of art may carry additional baggage with it, but yes, that in this industry, it means one thing and one thing only, which is what we're saying. And I'd emphasize too that it's true that expert testimony would support our allegations of this fact. So, I would anticipate that you could have an expert saying in the telecommunications industry, when you're talking about a 5G network, this is what it means. But of course, that isn't in the complaint, that's later on.
Really, what was in the mind of the executive who said that in the email, right? Or said that that's really what you have to prove. You have to prove, you agree, a heightened pleading standard for fraud, right?
Correct, under the PSLRA, but those don't get to falsity. Those are only about scienter, so whether the defendants knew or recklessly disregarded the falsity of the statement.
Could you address how the FCC deadlines affected the truth of the statement?
Affected the truth of the statement, of this particular statement, Your Honor?
Yes.
Yes, I think it goes to, I'm trying to think of how so broadly speaking, it's motive, or I suppose the state of mind of the defendants. So what happened is the defendants knew they had to pivot outside of paid satellite TV. They were doing this 5G network, and they really realized internally that they could not do both things at the same time, that they could not comply with what the FCC required them to do in order to hold on to their spectrum licenses, and then actually build out the network in a way that was feasible for commercial customers. So the FCC required a bare bones network that covered a certain portion of the country by a certain deadline. Enterprise customers, of course, required quite a bit more. It had to actually work for their businesses. And so they made the internal decision, we're going to focus on just build out the bare bones network so that we keep our licenses and don't lose billions of dollars in fines. And then on the other side, we know that we're giving up the fact that enterprise customers are never going to use this. That wasn't disclosed to the public. And so I think, turning back to statements 1 and 5 in particular, it emphasizes the fact that they were reporting essentially that they were doing the enterprise build out.
Well, were they giving up on the fact that enterprise customers never would use it? I mean, is that really ultimately what happened?
So yes,
Or was it just took longer than what people had hoped for?
I don't want to go outside of the complaint. It is true as a factual matter outside of the complaint that it didn't work, that Dish ended up selling its spectrum licenses to, I believe, to SpaceX and AT&T for some significant sum. I realize that's not in the complaint, but in fact, it did not work at all. What I might turn to is the second set of false statements, unless the court has other questions on statements 1 through 5 in particular. There's another set I'd like to highlight. Those are statements 11 and 12, again, from our chart. And they're similar, but I think in a little bit of a different
Well, counsel, at this point, I just need to ask you, you argue in your brief that the district court erred by addressing 2 statements as opposed to 19 statements. But didn't the district court address this motion based on the manner it was presented to the court?
The manner it was presented, I think I'm not sure if I understand what the manner that was presented to the court, Your Honor.
Well, did you discuss on a statement-by-statement basis the 19 alleged misstatements in your motion papers, in your opposition to the motion to dismiss?
Yes, and I think that all of those statements were included and were part of the briefing. I think the other important point is that the district court, the court also, it understood that was the way that we were presenting the issue as well. So it's true that
the district court said that you had divided these into 2 categories, and then it selected a representative statement from each category.
And I think that's true, Your Honor, that we can agree that the 19 false statements can broadly be broken up into different categories.
All right, you're okay on that, but then you have this 24-page exhibit to your opposition, which is really where you lay out in detail the analysis, but it's an exhibit and it's presented in bullet points. And I guess my question to you is, confronted with that format and presentation, why wasn't the district judge reasonable in the way he approached this issue? Because I think you're arguing that we should reverse and instruct the district judge to take these one by one, but this is a lot to expect anyone to untangle in your 24-page Exhibit A.
So yes, and I It is true that we are appealing the fact that the district court only considered 2 of the statements. I'm not sure, I wouldn't go as far as Judge Matheson, you were suggesting that we were arguing that the court has to go through every single statement in the same level, but I think that there are critical differences. And so to give just one example, the statement 1 through 5 was about the network. There are other statements that are specific about VONR, the voice over network capability that the network had. There are also statements about software development. There are other.
Okay, I need to, now we're sort of, I was thinking, well, there's either we take the 19 statements or we take 2 statements, and you're somewhere in between at this point. But my question really went to whether it was reasonable for the district court to analyze your complaint and ultimately grant the motion in the manner in which it did, or are you saying that that was wrong? To do it that way?
Right, may I answer? Yes. It was not correct for the district court to only consider those 2, but I don't take them, I think, farther position that it had to analyze all 19 statements to the same degree. I think that it could have grouped them into things like software, VONR, enterprise customers, maybe 4 categories or 5, something like that, that's the minimum level of specificity that would be required, and that just picking 2 when those categories are very broad wasn't sufficient because there were important details about, for example, software or voice.
Well, I mean, you're highlighting here, granted in a time-limited argument, 4. Are you saying that there were more than 4 statements the district court had to consider? I mean, than the 1, 5, 11, 12?
Yes, I mean, so I tried to order them by what we viewed as importance. And yes, 11 and 12 was the next set, and then statement 18, which the district court identified. And then, for example, statements 2, 3, and 4, they're in the district court's overall first category, but those are about integration, about bringing radios, compute, and software together. In our view, that's very different than talking about the field validation. So our argument is the district court, it grouped, building the network together, but under building the network, you've got software, you've got voice over radio, you've got integration, different things that I think, in fairness, the district court needed to look at those because there are different arguments and different statements about each of those.
And I want to talk, I know you're over in time, but we'll try to be a little flexible on that. Before I go on to ask a question about Sienter, what remedy would you expect to have out of this? I mean, if we were to say, oh, well, the court should have done 4 or 5 as opposed to 2, 1 or 2, I mean, would you ask to say that that was error that required us to remand for the district court to do a more fulsome analysis? Is that what would happen? I mean, you're not going to ask us to do it, right?
Well, Your Honor, yes, that is what, as to our first argument that the district court didn't do a thorough enough, review of each of the statements, that is one tack the court would take. I will say we certainly would prefer, because the court can review this de novo as a complaint, that it could just find that these are sufficient to establish falsity and scienter. That would, of course.
Did you clarify in your briefing what these categories of statements would be that you would think would be sufficient for us to consider? You were talking about, well, we could have done a number here, a number here, a number here in terms of buckets. If we were to do that, if we were to say error, we should do that. Is that clear from your briefing how that would play out?
So, no, if I understand the court's question, I think no, that we did not propose a separate, a more detailed set of buckets.
Categorization.
No, we did not do that. Okay. Because our argument was there are probably a couple of different ways the district court could do that. We don't want to say there's one particular way. Our argument is only breaking them into 2 broad buckets, that was too broad of a brush.
Got it, but you didn't provide guidance to us on how we should do it if we would propose to do it. Right?
Well, I think, no, Your Honor, I think that our argument is that the statements, in the first place, they do establish both falsity and scienter, and so there's sufficient allegations in the complaint for the court to find that it does state a claim, even under the PSLRA's heightened pleadings.
Let me go on to Sienter for a quick second, but you did not adopt this sort of enumerated approach as it relates to your Sienter argument in briefing. I mean, you in fact had categories of things that you had said established the fact that there was adequate Sienter, but you didn't go statement by statement in explaining why these statements reflected Sienter. So you adopted a different approach here for which your opponent actually found fault in that.
So I think we do have a separate argument on Sienter. We did, in the false statements, I believe, in the briefing, also discuss that as to them. I acknowledge it's certainly not, it's a question of page limits in briefing. If you want to make sure that you explain the points of scienter somewhere. And so we had both, in the particular false statements, we had an explanation, and then we had a broader one, just as its own standalone section, explaining that the defendants knew, broadly speaking, that the network was not functioning the way they were representing it to the public.
And so you're saying in your section of the enumeration of statements, you included a scienter argument as well?
Yes, in the argument section, is that?
I guess the point I'm making is, in the part of your brief that speaks scienter, there's not a statement by statement saying this statement A1, where the scienter is reflected in as it relates to this statement 1 by X.
Correct.
And so you did not do that, right?
In the separate section on scienter, that is correct, yes.
Okay. Did that anywhere in your brief?
Yeah, yes, I believe that, I apologize that I don't have the whole thing to give you a particular citation, but I believe that, yes, when we made the false statements, that we discussed the falsity of the statements, that there are discussions about why the defendants knew they were false as well. Those were much more abbreviated discussions because we pulled all of the allegations we had about scienter and put them into.
Why they knew they were false, but that doesn't, scienter is not necessarily why they knew they were false, right? They had to intend to deceive, right?
I think that they have to know that the statement was false or be recklessly disregarding of the fact that it was false. We don't have to allege separately a motive about why they would have decided to make those statements false.
And on the question of scienter, what, beyond you had confidential informant 3, beyond that, what did you have? And how did confidential informant 3 be situated to have knowledge to allow him to have scienter, he or she?
So confidential witness 3, I think in particular, sat in on both the, I believe it was weekly software meetings and biweekly 5G network meetings. And I think the important point to emphasize there is that in other securities cases, it's the defendants passively receiving information, and courts understandably are worried maybe they didn't absorb it, they received lots of information, how do you know that they knew it? What we have here, particularly with a confidential witness 3, is allegations about how the defendants were engaging. We're saying, why are there so many defects? Let's go through the JIRA tickets together. So the defendants are actively responding to the information that is being provided to them. They're not simply passive recipients of the information that they are being provided. And that, I think, is a very strong inference of scienter. The other smaller point I'd make on that is that Mr. Ergen in particular said, like he publicly disclosed, I go through the tickets, the JIRA tickets about defects every day. So he's actually on record saying, I go through these tickets every day. And I think that's a very strong inference that, in fact, they knew the problems that we're pointing to because he was actively going through everything. Thank you, Your Honor.
Good morning. May it please the court, Brian Frawley for defendants appellees. The well-reasoned decision of the district court here should be affirmed for at least 2 independent reasons. First, as was the bulk of this discussion this morning, plaintiffs do not plead facts showing that any actual DISH statement was objectively false, misleading, or demonstrate that DISH's forward-looking statements and puffery are actionable under the PSLRA and this court's precedents. Second, we heard very little this morning from my friend about scienter, and that's because they have very little to say on the subject, as was obvious from that colloquy. They do not plead specific facts giving rise to any strong inference of scienter, and they certainly do not even engage in the balancing test that's required by the Supreme Court and this court's precedents.
Could we focus on the scienter question for a moment? And in particular, opposing counsel's comments about how the speakers, the managers of DISH, were present in meetings that CW3 saw. Well, I want to get at the question of even assuming, as CW3 said, there was a certain level of engagement, as a matter of law, is that enough?
No, Judge Holmes, it is not. This court has said repeatedly in both of the Spirit Airlines decisions and Weinstein and Fleming that attendance at meetings is not enough. And reason that's not enough is that you have to show what the content of the information was that was conveyed to the speaker contemporaneously with the statement. And as Your Honor pointed out, it's not, the scienter in this circuit is not just knowledge of adverse facts. It's knowledge that the statement is likely to have a substantial risk of misleading a reasonable investor. There are two parts of just the cogent and compelling inference of fraud part of the Sienter analysis. Whatever happened at those meetings, which is not described in the complaint or in the briefs, they say meetings took place over a 2-year period and they talked about defects. They don't talk about how any speaker knew what those defects were, knew they were insurmountable. As this court ruled in Pluralsight, none of that comes even close to showing knowledge of a misstatement. Just because things are going wrong, just because delays are occurring, doesn't say that the delays are not capable of being overcome, doesn't say that technological difficulties can't be overcome. It doesn't even show knowledge of an adverse fact.
This may be an extreme example, but what I'm thinking about is a scenario in which one of the speakers was in that meeting, he heard these adverse facts, and asked questions about the adverse facts. That's one scenario. The other scenario is that speaker asks questions about the adverse facts and then says, well, I think we are really sunk. Turns around and makes a statement to the contrary to the public. That latter scenario, I take it, there's no disagreement, there would be scienter out of that.
I think that's probably correct, Your Honor, and that's more similar to Your Honor's opinion in the SEC versus Gen Audio's decision, where somebody made up facts, knew the adverse facts, doctored evidence to make up support for his version of the events, and then lied to investors. What the best case the plaintiffs have here is that defects were found remarkably in a network that nobody ever built before, that was going to be built in 3 times quicker than anybody had ever built it before. Defects arose. The defendant said in every single one of those earning calls that are in the record in the appendix, we have problems. We're going to have problems. The problems are going to arise, and then we're going to try to fix it. The record here doesn't support the way that the plaintiffs are portraying this in any way, shape, or form.
What my question was designed to get at is in part the notion of, and you alluded to this some, I take it under the law, it's not enough that you know bad facts. There has to be evidence that you drew an inference that would be counter to what you later articulate, right?
That is correct, Your Honor. And this court has made that clear on a number of occasions, that you have to know the adverse facts and know that your version of the events was likely to mislead an investor. We haven't had either of those two elements here. There's no pleading of specific facts, of specific pieces of information that contradicted with what anybody said. And it would be almost impossible to do so. The fact that we had 17 minutes of argument this morning about how somebody interprets the word field validation, how could you know that? How could you ever plead? I watched it right there. How could you ever plead that the speaker knew that was going to mislead somebody when nobody can say what it means?
I mean, the plaintiff in this case, the appellant says there's only one way to interpret the terms a successful field validation and or a network functionality. What's the response to that on your side?
Well, Your Honor, first of all, let's start with their complaint. This is what their complaint says. This is paragraph 122. A text message was sent to Dish's headquarters to validate that the 5G network was functional. So a text message was sent from the field to Dish to validate the network. What part of that isn't a field validation? I don't understand, but the argument, as we heard it this morning in response to Judge Holmes' questions, they say that CW3 says that this has some unique meaning that some technical people know about. As was pointed out, there's no argument that's what a reasonable investor knows. But the argument here has always been that you need to read the context. But the context entirely refutes what they just argued to this morning. The network didn't exist. In December of 2020, the network was going to start construction in April of 2021. There was no network. How could anybody interpret that to have tested all of the network, all of its functionality, voice on a network that doesn't exist? How could anybody interpret it that way? They can't. But more importantly, as I think Judge Holmes also pointed out, in Hampton, this court said, showing that there's 2 alternative conclusions from a statement doesn't plead a misstatement. That's not pleading a misstatement. They need to plead specific facts that their version is the right one, not a one, the right one. The Tesla case from the Ninth Circuit says that as well. Part of the problem here with this is that the plaintiffs have a sort of fundamental flaw in the whole theory that they're espousing here. They're contrasting two entirely different things. The save the license mantra that was the subject of their briefs has nothing to do with the Vegas market, which was the subject of all of Dish's comments about its network. Nothing about Vegas was saving the license. Vegas was being built in 2021. The first hurdle in the FCC license requirements wasn't until June of 2022, and the second one not until June of 2023. Vegas had nothing to do with saving the license, and Vegas was operational, open to consumers in May of 2022, so it couldn't.
Could I just ask you this? It seems, at least at some points, that the appellants are arguing falsity by omission. In other words, on the field validation statement, omission of information about lack of software integration, or omission of information about lack of functionality, or inability to launch by the third quarter of the next year. So it seems that there are these affirmative arguments about false statement, but there's also these arguments about material omissions. Could you address that, please?
Yes, Judge Matheson, I was hoping to get to that anyway. I want to unpack that a little bit. So to start with the first part of your question, that's not a viable claim under the securities laws. An accurate statement cannot be misleading by omission. That's McDonald and Williams from this court. The omission has to show that the actual statement was false, not that it was incomplete, not that there were nice information I would have liked to have known. The statement has to have been misleading on its own. And a field validation isn't misleading on its own. And any of the other statements that they refer to isn't either. That's correct, Your Honor. For example, in Hampton, this court said that the use of proprietary in reference to a transaction was not false because the plaintiffs hadn't shown that the label doesn't fit the product. They can't plead a misstatement just by merely alleging that investors may ascribe a different meaning to the statement. Again, in Hampton, this court said that an article with an alternative conclusion doesn't show that the statement was untrue or even misleading. The misleading fact has to change the omission has to change what was actually said. But that's why the context here matters so much. The plaintiffs say that all of these statements implied that Dish had done so much, but as I alluded to earlier, there was no network. The same statement said we're going to start building in a couple of months. It couldn't mean that we tested or all of this stuff works. They also say that the field validation and bringing network software together all implied that we had a fully integrated network. It was all built and it was integrated. But again, Dish said the opposite. This is quoted at page 34 of our brief. It's 80 of the appendix. Dish said that it would first build a network, then it would put the pieces together, and then would see if it worked. This is what it says. Once you get through the transition stage, it's all about execution. And there's certainly significant risk for us as we go execute. We have to first deploy our network, then we got to put it all together to make it work, and there's certainly going to be substantial risk. There's certainly going to be a lot of problems. Dish said once built, the network wouldn't be running but crawling. It told investors to be skeptical because we'd never done this before. What they say the statements implied is impossible, given what Dish actually said. Not even implausible, impossible. In Williams, this court said there's no misstatement because the defendants, quote, made quite explicit what further steps were necessary. The same thing is true here. Judge Matheson also asked about the statement about a projected third quarter launch. On its face, that's a projection. It's covered by the PSLRA safe harbor, and the plaintiffs waived any argument about that by not briefing the question. But it's also not shown to be false. The only thing that they based their entire claim that Dish didn't have a basis to project a third quarter launch is one CW, and this court statement is to say that an unidentified CW can't be the sole source of a misstatement. But all that CW says is that there was a technological change from an existing cloud vendor to Amazon, and that made a third quarter launch implausible, improbable, whatever the words he wished to use.
Counsel, could I just ask on the CW question, leaving aside the sole source point that you just made, on a motion to dismiss, when the complaint relies on a CW, what is it permissible for a court to consider whether the complaint has adequately supported reliance on a CW from the standpoint of reliability, credibility, or is that something that's not appropriate to consider at that procedural stage?
So the first half of your question is yes, and the second half is no, so let me go through that. Credibility determinations clearly are not part of the motion to dismiss process, whether it be a CW or anybody else. But the district court is, and Adams and in Hampton made this clear, that when you have unattributed sources, whether they be a CW or just references to internal reports without any indication about the source or reliability of them, it's part of the particularity review that the court does. And this court has said repeatedly in Adams and in Hampton that when you have unattributed sources, whether they be CWs or other things, that we look for more than one, and we look for other indicia of reliability in determining whether or not is a particularized pleading of a misstatement. And we submit here whether you credit CW at his word or you cast some doubt about them because he's alone. There's nothing remotely here that shows a misstatement whatsoever.
And there's a distinction, right, between credibility and the question of whether the CW was actually situated to see the things that they saw, whether they were situated to have contact with players such that they could be able to make a conclusion, right?
Right, and that plays even more so into the Sienter part of it, but you are right, Judge Holmes, and particularly in both of the Spirit Airlines cases, this court made clear that when you have CWs that are not very close to the speaker, so they won't know what other information the speaker has, that we don't typically credit those kinds of CWs in this court in either finding a misstatement or in finding Sienter. And just before, as my time is up here, I want to get to one more part of the Sienter argument, and that's
the other side. So if you want to take a few minutes, 3 minutes tops, you can do that.
That's fine, Your Honor. I think that I probably have covered most of what I'd like to cover, but the ultimate conclusion in the Sienter analysis requires a so-called tell-lab balancing, and that is looking at the inference of Sienter presented by the plaintiffs, and there must be a cogent and compelling inference of Sienter before you get to balancing. But even if you were to assume that they got there and they didn't, under this course precedence, there is no way to perform the tell-labs balancing and find a strong inference of Sienter here. We talked before about the ambiguity of the statements. In Wolf, Weinstein, Nakumton, this court has said repeatedly that ambiguous statements are ill-suited to support a Sienter. The Supreme Court said so in tell-labs itself. It says ambiguity and omissions count against Sienter. There's the absence of motive, which we haven't talked about yet, but this court has repeatedly found that dispositive. In McNamara, Williams, Small, in Gold Resources, this court said that the fact that an 18% stockholder was not alleged to have sold his shares, and that was actually all the defendants collectively, refutes Sienter. Here, Mr. Ergin owned 52% of Dish's equity. By plaintiff's theory, he was the orchestrator of his own fraud. He was the worst outcome of anybody in this situation from his own fraud. It makes no sense. And this court has said repeatedly, fraud theories that make no sense do not have a compelling inference of fraud. And then the last thing is Dish.
Put a fine point on it. Why would it make no sense? He owns 52%, but why would it make no sense?
There's nothing to be gained. There's not only nothing to be gained out of this fraud where you are trying to artificially inflate the stock in order to deflate it 2 years later. His stock holdings didn't change. So he not only didn't get anything out of it, he just put off to the future the inevitable in order to incur losses later by their theory. as a stockholder, he's not alleged to have transacted in Dish's stock in any way, shape, or form. And so he not only didn't benefit it, but if they're right that this fraud produced losses for the Dish equity holders, he was 52% of those equity holders. And lastly, this court has said repeatedly that a company's candor about the risks in its business strongly undermines the scienter, as well as in Anderson and Gold Resources. This court said the risks of the business were fully laid out for investors. As our brief makes clear, that's true in spades here.
Counsel, I know you're over time, but could you just take a few seconds to addressing 2 statements versus 19 statements issue?
Sure, Your Honor. So as seasoned appellate jurists, I think this court is well aware that judges and a chief judge of the trial court are often faced with pleadings with 19 statements and sort of have to do some balancing. This court does it all the time. It did so in level 3. It did so in the Spirit Airlines cases, but it doesn't really matter because that's not what the district court did. If you read the court's opinion, it makes conclusions about the entirety of the complaint. It says that it read the entirety of the complaint. It says the entirety of the complaint does not state a cause of action, a misstatement, or scienter. It took what it perceived to be the 2 best cases in plaintiff's categories and addressed them specifically as an example. And the plaintiff here, I frankly endorses that because my friend here basically described all of their misstatements in buckets. So it's a little hubris to complain about what the district court did when that's the way they presented their case in the district court, and they did so again here. But apart from all of that, it doesn't matter. This court's review is de novo. However the district court went about reviewing these claims doesn't matter. It's not a basis for any reversal or finding a reversible error. It's just a way for my colleagues to avoid pleading a case for each one of their misstatements. Thank you, Your Honors.
No. Case is submitted. Thank you for your fine arguments. Bondi, counsel for appellant, if you'd make your appearance and proceed, please.
May it please the court. My name is Matt Crotty. I represent Will Berry. I'm going to start by addressing the concept of exhausting administrative remedies, and then I will go into the district court's dismissal and how it erred in dismissing the retaliation, discrimination, and then hostile work environment claims. As it relates to the purpose of exhausting administrative remedies under Title VII of the Civil Rights Act, an aggrieved, once they learn of their, a discrete act against them, in the federal sector, they have to contact an EEO counselor or somebody logically connected to the EEO branch. If that doesn't resolve, then at the agency level, they file an agency-level complaint of discrimination. Once that discrimination complaint at the agency level is filed, then the agency investigates the claim. In this case, a complaint of discrimination was filed at the agency level, and the agency conducted a very thorough investigation. A supervisory special agent from the FBI interviewed and got statements from over 17 witnesses, and then compiled a 328-page report of investigation that related to allegations that occurred beginning in 2020 and then all the way up through 2023. That is the purpose of exhausting administrative remedies, to allow the agency to investigate and then possibly resolve the matter. The purpose of exhaustion is not, and there's case law that we cite in our reply brief, to set up a a case for judicial review, and also charges at the administrative level, they're to be liberally construed. So with that concept in mind, and then also with the fact that on summary judgment, reasonable inferences need to be made in favor of the non-moving party, I'm going to move into the district court's dismissal of the discrimination and retaliation claims.
And to your exhaustion point, though, at the time that Mr. Berry first spoke to the EEO counselor, the EEO counselor noted that his claims appeared to be time-barred, and that he had no explanation for why he did not respond within 45 days as he was required to do. Yet exhaustion, it exists for a reason. I mean, you're supposed to raise these claims in a timely manner. He did not. So whether the FBI did an exhaustive investigation or not, or did a comprehensive investigation, doesn't go to the initial question of whether he did what he was supposed to do under the regulations of the agency, right?
If we take a step back, though, and look at granted it's a district court decision, but it provides a good framework to look and address this exhaustion question that I think the court's getting at, and that would be the Johnson v. Glickman case out of the District of Kansas, and that sets out a three-factor test to determine whether, in this case, Mr. Berry timely contacted somebody associated with the EEO program to begin the process so exhaustion would occur. And in this instance, and I'm going to quote here, the EEO has held that in order to sufficiently initiate contact, the employee must contact an agency official logically connected with the EEO process, even if the official is not an EEO counselor. That's factor number one that I'll get into quickly. And then factor two is to demonstrate an intent to begin the EEO process. And then factor three, to allege that an incident in question is based on discrimination. So let me address factor one, which was before the district court, and again, on summary judgment with reasonable inferences in the non-moving party. Here are two policies that was before the district court and that I'd like to highlight. The first is the FBI harassment policy 1038D, and that's on volume 2, page 161. Specifically, it's paragraph 5.3, harassment based on race. And paragraph 5.3.2 says if the employee is afraid of or uncomfortable with confronting the alleged offending party, and this is Mr. Berry back in August, September 2021, the employee, Mr. Berry, the employee, is encouraged to report the incident in writing or verbally. He reported it in writing to a higher level supervisor. He didn't do that. And or, here's the important part, to the inspection division, and then this is the key phrase that I can't emphasize enough, to protect all legal rights and to put the FBI on notice in order to address this behavior. So all legal rights, the employee's all legal rights include rights under Title VII to pursue and vindicate his Title VII rights that were being violated. So that's FBI policy.
There was no mystery who the EEO counselor was. And when he was confronted with the time bar, he offered no explanation as to why he didn't do it. Right then and there, he could have said that I was concerned and I did X, Y, and Z. He didn't do that. And why is it not the case? I mean, this structure that he reported under was an internal affairs structure. I mean, those two things are different. I mean, I don't even have to know a lot about the FBI to know those two things are different, aren't they?
Well, that's what the district court said, but I would say that
counsel, let me follow up on that. If it's not as Judge Holmes said, when he sent the emails in August of 2021 and September of 2021, that was after the investigation had started and he'd received notification of the WebTA fraud investigation, which was in March of 2021, right? He already knew that at that time.
He was aware, yes.
In the emails, did he say anything about his belief that he was being investigated because of some discrimination? Or did he just say, hey, my supervisor is saying some derogatory things that is not appropriate?
No, he did not say that in the emails, and to I think the point Your Honor's getting at is that...
But that's where you want us to believe that the claim was preserved and exhausted, right? In the emails.
the hostile work environment claim was preserved and exhausted in those two emails of September and October. The discrimination retaliation claims were preserved on January 11th, 2023, when Mr. Berry went to the EEO counselor, the EEO counselor herself, and laid out what had happened from 2020 all the way up through 2023. The main point that Mr. Berry made when he went to the EEO counselor on or around January 11th, 2023, related to that now he knew, Mr. Berry knew that he was being recommended for termination from the FBI due to this alleged house hunting trip violation. So he knew that, and he also knew, Mr. Berry also knew that at the time, that Mr. Hall and then his replacement, Mr. Fancher, had treated two white, similarly situated people differently. So under Title VII and the case law, right there before the EEO counselor, Mr. Berry brought forth facts that he was in a protected class, he was being treated subject to an adverse employment action, the potential termination, and then he alleged comparative evidence of other people being treated better than him.
You said the hostile work environment claim was preserved by those emails. Well, in his EEO complaint itself, there's this box to check for harassment other than sex. He didn't check that box. What do I make of that?
I believe there's case law that says that one doesn't look at the actual boxes checked, but they look at the charge, the agency charges.
I read the charge too, and I didn't see any suggestion of well, he didn't use those words, nor did he suggest necessarily that he was being harassed.
I would disagree. If you look in the two emails, the September and August emails, he does mention hostile work environment. So he might not have said the word harass, but he says hostile work environment, and they're fairly synonymous. But more to the point, though, as it relates to the discrimination or retaliation claims, as of January 11th, 2023, then Mr. Berry, timely, once he knew that he was subject to, once he learned of the effect of this investigation that began back in March of 2021. And then, Your Honor, really quick, Mr. Berry in his agency charge, he's saying that the motive for being subject to this investigation was Mr. Berry having took a knee when he was activated in response to the George Floyd protests. So that was the motive that originally led Mr. Hall through Ms. Montgomery, he alleges, to make this house hunting trip referral. It wasn't, because I get your point about the timing, that he made the complaint after he became aware of the investigation, but it's his complaint, and he says it towards the end of his EEOC charge, that it was Mr. Hall and then Fancher retaliating against him for having taken the knee earlier, a fact that both of them were aware of, had expressed discontent about.
What I'm struggling with, though, however, is, there are a lot of allegations of conduct that, arguably was quite offensive. He knew about these things. I mean, he knew about these things in 2021. I mean, why in the world did it take him to the time he went to the EEO counselor if he's claiming that somehow or other there's been some racial discrimination against him? He knew about this stuff then. I mean, what light went on beyond the fact that he was being investigated that would have caused him to go to the counselor then that didn't exist prior to that point?
As it relates to...
He was in 2020.
The knee was in 2020. The domino effects of that continued in August, September 21, and then I believe it's in Mr. Berry's declaration that as he made these two complaints to the IPU, which is under the INSD, he was told that, hey, if you keep making these complaints, it's just going to start the process all over again. So that's why he stopped. So that's the answer to the first question. And the second part is he hired an attorney once he knew that he was getting not investigated, but subject to possible termination, and an attorney who...
Right, he had an attorney with him at the time he filed his complaint of discrimination, right?
Yes, after contacting the EEO counselor in January of 2023.
The question I have then is, as I understand, you're trying to tie this all together and get this sequence of events and to argue that he exhausted and properly timely exhausted his complaints. But in the complaint, it says, these are the words, it says, "To be clear, comma, Bill," and it's Bill Hall, but it says, "Bill retaliated against me for opposing race discrimination, taking a knee at the BLM protest." And but this is in 2023, right? And he says, "On account of my race," but then he says that retaliation and the discrimination was by causing the WebTA housing hunting trip fraud allegation to be investigated. And he knew about that in March of 2021, right?
But an investigation is not, he did, Your Honor, but an investigation, yes.
Not that I was recommended for termination later, but that I was investigated.
But there's and we cited on page 7 of our reply brief, the Lincoln v. Maketa case, which says that being told that you're under investigation, that is not an adverse action, it is not a discrete act, that didn't, so as a matter of 10th Circuit law, he was not obligated at the time to.
So if all that happened was he was just investigated for this, and that was based upon, as you say, racially motivated, that wouldn't be an adverse action? Even if it turned out in his favor? The fact that he had to go through an investigation, that's not an adverse action?
Under the case law I'm looking at, I believe, for these purposes, no.
Well,
But when he learned that the FBI, years later, apparently the process takes some time, but when he learned that the FBI was then going to fire him, he had the facts which he conveyed to the agency that I am being treated differently. I was subject to investigation, now I'm looking at being fired for this reason. They're similarly situated, non-African-American agents that have been treated better by the same alleged adverse
Counsel,
actors.
the letter didn't fire him, did it?
No, the letter did not, but the letter said that.
There was a proposal, and then it set forth various procedures he could invoke. Is that, why is, if you're saying the previous investigation wasn't an adverse action, why is this an adverse action when there's been no termination? It's just a continuation of something that you seem to be saying isn't an adverse action.
Because now we're looking at a material change in one's job position. As I understand it, Mr. Perry,
It doesn't say he's being fired. There's a proposal. The letter proposes his dismissal.
but with the proposal then, as Judge Heil was getting at, that's when he had the,
Well,
that's when Mr.
I'm in your complaint where, I mean, the letter is mentioned only once in the complaint. And is there any discussion of it being an adverse action in the complaint?
There is, towards, I believe, the paragraph 80 or thereabouts, that's when, it's alleged that Mr. Berry is informed that he is being subject to termination. And when you're subject to termination, you're not working anymore. You're on administrative leave as you begin to, combat that process. So unlike just under investigation where Mr. Berry was.
Are you also arguing that this, what's referred to in the briefing is the non-recognition event? How is that an adverse action?
So under hostile?
That they say that, they didn't have him help with the new folks and instead use someone less experienced than him. I mean, maybe that was a slight to him, but why is that an adverse employment action?
I'm going to split some technical hairs here. So an adverse employment action which is a discrete act under the Martinez versus Potter case, that's a demotion, failure to promote, a non-transfer, to use those 10th Circuit examples. I'll point to the Russell versus Driscoll case of this circuit of this year, where it says a hostile environment claim asserts that a series of.
I was thinking of it not in hostile terms, hostile work environment, but you rely on it for retaliation. And there you need an adverse employment action. So how's it an adverse employment action?
So under Burlington, Northern Santa Fe versus White, which is a U.S. Supreme Court case that the defense cites, that says a couple points. One, context matters, and I'll get to the context quickly. Two, for retaliation, the adverse action is something that would dissuade a reasonable person from pursuing a charge of discrimination. And the Burlington case gives an example of an adverse action of not being, and I think this is on page 68, 69 of that opinion, it gives an example of not being invited to lunch. So context matters, and here's why that context is important in this case. You have, in this instance, Kalen Fancher. And Mr. Fancher, this was all before the agency when it did its investigation, Mr. Fancher was enraged that Mr. Berry took a knee. That's volume 1, page 176. Mr. Fancher was alleged to have said that Mr. Berry should have been kicked out of the FBI because of that. That's volume 1, 100, paragraph 29. It was investigated or alleged in the EEO complaint that Mr. Hall discussed in 2021 with Mr. Fancher having learned of Mr. Berry's emails to the OPR calling him a coward. And then you have Mr. Fancher refusing to act upon being told by Mr. Berry that he was being discriminated against, even though FBI policy required it. So that's Mr. Fancher. And then the context is this. You have, so Mr. Hall's gone, Mr. Fancher's there, he's the heir apparent, and so Mr. Berry already knows that the Hall replacement does not like him for those reasons. But and again, summary judgment, reasonable inferences, you have the non-recognition that has really three, I'll say, acts that would dissuade a reasonable person from pursuing a charge of discrimination. First off, it's essentially stifling career advancement. It's the first step in, Mr. Fancher, he's not going to go right to termination. Instead, he's going to build the record. You start by building the record by not really relaying the facts. And the fact was, at that time, Mr. Berry had the highest arrest records, despite all of the things that he was dealing with as a result of his leadership. Two, so you have the stifling of career advancement. The other part of this non-recognition is that it weakens your reputation among peers. He's again, the highest arrest records. You have these new peers coming in, but he's not referred to them. So what do those peers think? And then you have the effects on Mr. Berry and his confidence as a law enforcement officer. Why am I continuing to do this if I, don't get the recognition? Then more importantly, it's okay. So I know that I have the highest arrest records. I'm not being recognized. What's next? When's the other shoe going to fall? So I don't know, does that answer your question, Your Honor?
Thank you, counsel.
Looks like I'm over.
I just want to clear this up. There doesn't seem to be an allegation that there was retaliation from taking the knee by his transfer to New Mexico. Is that right?
That's correct.
You don't allege that.
Yeah, he's not. That's not retaliation. Yes. Any other questions?
No.
Thank you, Your Honors.
Good morning, may it please the court. Counsel. Paige Messick on behalf of the Attorney General.
Ms. Messick, do you accept that the non-recognition of workplace accomplishment was an exhausted claim?
The non-recognition of workplace accomplishment was exhausted. He did mention it in the EEO complaint. That was what the district court called his sole, timely, and exhausted accusation. But as Judge Matheson just alluded to, it does not constitute an adverse employment action under the case law.
Well,
and I would
was that a theory that was advanced by the government below, or was that a theory that the district court used to deny the claim?
both. I believe that the government advanced that theory very briefly in some of the later pleadings, and it may have even been in footnotes. The district court then did say this is not enough for a retaliation or hostile work environment claim, and Barry has never suggested.
Document are you talking about? This I'm not aware that it appeared to me that the district court use that itself.
I don't have it before me right now, but I can try to try to find that in the record if it's important to the court.
I don't want to take your time to do that right now. Why don't you talk about, to the extent that the adverse action or not is on the table here, what do you make of the argument that you just heard from opposing counsel as to the nature of why that would chill a reasonable person?
If I may just first note that even if the district court did come up with this itself, Barry has never objected to that on appeal. But as to whether this can be an adverse action that's sufficient to sustain a retaliation claim or if it's standing alone, a hostile work environment, no, it's not. And I would point to this court's decision in Stover in which an employee did not receive a performance award and was not assigned a special project that he thought that he was best suited for, or it may have been she, I'm not entirely sure. In any case, the court in Stover said that's not enough for a retaliation claim. And Mr. Barry's argument here that it is enough to be not invited to lunch, this is the first time that I've heard him raise any kind of argument like that. He didn't engage with Burlington Northern at all in his reply brief. But I think that under Stover, it's quite clear that this kind of petty slight, this is at most a petty slight, is not enough to sustain either of these types of actions. Also, the court case in Morris said that sort of sporadic comments demeaning an employee's quality of work are not enough to sustain a retaliation kind of claim. So this is his sole timely and exhausted complaint, and he cannot meet the standards to establish either of those claims.
Isn't he also trying to sweep in statements, alleged hostile work environment statements, by hitching it to the timely non-recognition claim?
Indeed, he is trying to do that.
Yeah.
So first, we don't believe that the non-recognition is alleged in the hostile work environment claim. So if you're looking at his amended complaint, there's nothing in there that would give you the idea that non-recognition was part of his hostile work environment claim. But even if you say, okay, let's say that it's there, he can only make this timely by hitching it to the non-recognition. If the non-recognition is of the same, is sufficiently related to the other acts that are alleged to constitute the hostile work environment to be part of the same kind of environment. And this is the Morgan case. And under the Morgan analysis, you look to factors like the nature of the acts, the perpetrator, and when they occur. And here, the other acts that he has alleged that constitute the hostile work environment are all overt racist comments. You look at the allegations are that Bill Hall said, no, there should be no interracial marriage. People who knelt at these protests should be killed. He's going to be a problem because he's interracial. These are the kind of comments that are the bulk of the hostile work environment claim. And then you compare that to the allegation that Fanter told a new agent to go ask questions of two other people, not even instead of Barry. This comment had nothing, did not even allude to Barry. But when you take this non-recognition, you compare it to those other racist comments, you see that there is one thing that is not like the others here. And just as in this court's case in Tadimi, these are just qualitatively different kinds of acts. In Tadimi, for instance, it was not enough that there was racist graffiti, racist epithets, a noose around a clock. That was not enough to pull in another race-related incident of physical intimidation, even though they all shared that common thread. There has to be something stronger to link them there.
Counsel, with regard to exhaustion, Mr. Barry, at least on this appeal, is alleging, and he's alleging this was not addressed by the district court, he's alleging that he timely exhausted a claim that he was retaliated against in his complaint by the proposed dismissal. And he says the judge didn't address that. So he says he got the dismissal letter or the proposed dismissal letter in January of 2023. He did submit his complaint within the time, if that's considered. What's your response to that?
Our response to that is that allegation is not in the amended complaint. It is not one of the discrete acts of retaliation or discrimination that he lists in his amended complaint. So we would agree that if the alleged proposed termination, if his amended complaint alleged that, then yes, that would be something that was exhausted. It was in his EEO complaint. But in this instance, his problem is that he did not carry this allegation from his EEO complaint forward to his amended complaint. He lists specific actions as his discrete acts of adverse employment actions, and he doesn't include that. Now, the government, the Bureau pointed that out below, and he essentially ignored that point. On appeal, we pointed out again when he says, hey, the district court ignored this, and we pointed out that's because it wasn't in the amended complaint. And he finally, in reply, brings up liberal pleading standards as if to say, you should read my amended complaint to encompass the proposed termination, even though he specifically listed out things that were not the proposed termination. But even under liberal pleading standards, even under notice pleading, we still need to have notice of what these claims are. The identity of his adverse employment actions is a crucial piece of his claim, and it shouldn't be a moving target. It's not something that he can change up in his briefing. I also wanted to touch, while we're on the discrimination and retaliation claims, on the idea of notice to Barry, with Barry's idea being that if he didn't have notice of the 45-day requirement, then he didn't have to follow it. But he is raising this argument in the wrong forum. If you think you don't have notice of the 45-day requirement, you can ask the administrative agency for an extension. And one of the grounds that you can ask for an extension on is that you didn't have notice and you were not otherwise aware. But he never asked the agency for an extension. And he's never argued, below or on appeal, that the agency abused its discretion in not sua sponte offering him an extension for his untimeliness.
What about that regulation that he just cited? What do we do with that? The one where supposedly the FBI had a regulation that allowed him, if he faced racial discrimination and was concerned about raising it with his immediate supervisor, he could raise it with somebody else. Why didn't that allow him to exhaust his racial discrimination claims?
So Mr. Barry is selectively citing to one page of that harassment policy, but if you flip forward, I think about 2 pages, you will see that it says that someone who is attempting to raise a claim that they have been the victim of this type of environment must take that to the EEO counselor within 45 days. And so he wants to point to one piece of the harassment policy without reading even the entirety of the same section, in which this 45-day requirement is clearly stated, as it was clearly stated in the No Fear Act training that he received 3 or 4 times before he made it to an EEO counselor.
Nice segue. I was just going to ask you, on the No Fear Act, is the question of whether it's sufficiently clear, is that a question of law or is that a question of fact?
I don't think that whether the No Fear Act slides are sufficiently clear is really at issue at all as a question of law or fact, because this is basically another argument that he should have taken to the agency, to the OEEOA, asking for an extension. Basically, I didn't know that it was a 45-day requirement because your training was bad. But he didn't do that, and he's never asked for anybody, the district court or this court, to review the agency's lack of sua sponte action here. I also wanted to discuss this Glickman case that he relied on in his reply brief for the first time on appeal and then an oral argument here. That's a 2001 district court case from the District of Kansas that says essentially the EEOC employs a close enough rule under which it considers that 45-day standard to be met if the employee contacts agency officials, an agency official who is logically connected with the EEO process, demonstrates an intent to begin the process, the EEO process that is, and then alleges some sort of discrimination. But the 10th Circuit has never adopted this standard. 10th Circuit precedent, such as in Hickey, says that you must contact an EEO counselor. There's no unless you do something close enough. And the court should not adopt that standard here because the 45-day regulation at 1614.105 isn't ambiguous. There's no reason to look to what the EEOC has employed here. That regulation doesn't include anything like a close enough, logically connected type of provision. And even if you did apply the Glickman standard, Berry can't meet it anyway for the reasons that the district court explained. If the court has any further questions, I would be happy to address them. If not, I will see the rest of my time. Thank you.
So, and the court will be in recess till 9 a.m. tomorrow.
You don't have to hurry.
They're not using the court for anything.
Right, no, yeah, no special things going on this week.
I didn't catch your name earlier.
I am Laura Smith. I'm an attorney in the clerk's office. Yeah.
We call the clerk's office sometimes and we speak to people and we know names, but we never know faces.
You're usually talking to case managers,
Yes.
Non-lawyers.
Right.
We do that on purpose.
Yes.
So.
Yeah, fair.
And our names don't go out on waivers anymore. We used to put our names on things and now they just don't.
You know, I hadn't noticed that. I was curious.
Yeah, it's just always the clerk.
It's always.
Yeah, and if judges' names are on it, it all goes out per curiam. It's just, policy shifts of the court and things like that, so.
Okay.
And I don't get the insurance coverage like the clerk does, so,
Oh,
putting my
right,
name
so
on
best
it
not to
is-
have.
Right,
Yeah.
right. If
Yeah.
I don't put my name on something, I'm not gonna complain about that.
Makes sense to me.
Yeah, exactly. Well, it's fun to have Judge Heil here, so.
That
yeah.
was, yeah.
Are you here the rest of the week? Are you going home?
This is
today?
that was my only case I headed home.
That's unusual. You're usually here multiple days, right?
Yeah, well, with the criminal docket, we often get set on multiple cases.
Yeah.
But there are a couple of criminal cases from the district set that they're not until Thursday, I think.
Okay, yeah, and it's not your responsibility?
Everything's sort of my responsibility at some level, but those are not my cases.
Are you mostly handling the appellate work now for the district?
Yes.
Okay.
Yes.
And then how many people do you have working for you, like full-time appellate people?
We have 5 full-time appellate attorneys.
Really?
That is as of Monday.
Oh, really?
We've had 4.
Okay.
And only recently we actually got one of them back from a detail. So we have basically doubled the size of
Wow, that's
the
fantastic.
section for my purposes at
Yeah.
last month or two. So
Well, I know the district's